He, all persons having business with the appellate, join here, in the attendance, and shall be heard. You be seated.
Good afternoon, everybody, and welcome to the Appellate Division First Department. We have more than 7 hours of argument time requested, so I don't think you probably want to stick around quite that late. I know we don't. So please remember that we have had your briefs and records. We are familiar with your cases, and we just want you to hone in on the really important issues. For those of you, if there are any that have not been here before, when the white light goes on, that means you have 2 more minutes. When the red light goes on, we do ask you to wrap up what you're saying. If we still have questions, we might nonetheless go past the light. The light's for you, not for us. Okay, so we're going to call the calendar. Please, both sides stand up when you're called and let us know how much time you are requesting. People versus Christopher Thomas.
Request 4 and 2.
4 and 2, and you got it. 4, 2, and 4. Thank you. People versus Tyler.
Good afternoon, Your Honors. Appellate request 7 and 2.
Okay, respond. Okay, 7, 2, and 7. P. William is submitted. Cantor Fitzgerald versus Avio Health.
The appellant request 6 and 2, Your Honor.
Okay, and respondent?
6 minutes, Your Honor.
You got it. 6, 2, and 6. People versus Pointer. Okay, 5, 2, and 5. Deer Park versus Nationstar Mortgage.
Your Honor, appellate requests 8 and 4.
Yes, respondent?
Respondent request 10.
Okay, I'm going to give you 7, 3, and 7. If there's additional questions, we'll continue. Next case is Estate of Chung Lee versus Lee. Respondent?
Responding 4 minutes.
Okay, we're going to give you 7 and 2, and I'll give you 4. Thank you. Okay, now the next 9 cases are being heard together. Do I have to call them all out individually? Well, I'll call out the petitioners' names. Fordham Hill, Westchester, CM Water Group, Global View, SKMF Bryant, 2886 Roosevelt, 1230 Franklin, 205 West 262nd, and 243 East 32nd Street. So who is the petitioner? But mostly it's the respondent is the main appellant, right?
The city, of the
Ci-
9 matters, there are 7 matters in which the city is the appellant, and then there's 1 cross appeal and then 1
Right.
appeal from the respondent.
Okay, so are you the city?
Yes.
Are you the same attorney? Are you going to be arguing everything?
We would request 3 presentations. We've conferred with opposing counsel. We think that the Fordham Hill to 205, the city is the appellant, and there's a common issue. So
Right.
we request that I'll argue that, and then
Okay, so how much time do you want for that? Those 7, I guess it is.
for those matters, the city requests 7 and 3.
Okay, and respondent?
I'll request 8 minutes.
Okay, 7 and 3 and 8, and that's on the first, that first group. Okay, then what about 205 West 262nd? I know there's a cross appeal on that.
So we're the appellant on that cross appeal, and I would request 7 and 3.
But
We have a request for the city request 7.
7 and 3. So I'll give you, I don't know if at that point you're still going to need 7 and 3, but I'll give it to each of you anyway. And what about the last one, the 243 East 32nd?
Good afternoon, Your Honor. I am representing the appellant in that matter.
Okay.
7 and 3, and that's a totally different issue than.
Well, I know, we're familiar with it, but we will have been talking about this for a long time, yes. And respondent?
You also request now 8 minutes.
What?
8 minutes?
Okay, so I'm going to give you 6, 2, and 6 on that last one, okay? All right, you can be seated. Thank you very much. Thank you for conferring together in advance on that. People versus Richard Williams is submitted, and Etkin versus Sherwood Residential is also submitted. So we will begin with the first case for argument, People versus Christopher Thomas. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Abigail Everett, Center for Appellate Litigation, for Appellant Christopher Thomas. Turning to the conditions of probation's issue, this is a condition of consent to search home, person, and vehicle.
As far as you are concerned, what is the standard for that we should be looking for based on our First Department law?
Right. Well, first, based on letter law in the Court of Appeals, the condition of probation has to relate to the defendant's rehabilitation. Here, the probation department asked for this condition, citing it was vital to safely supervise the offender, protect the community, and the probation officers. That's the only basis cited in this record for the condition. Now, this court in Hall considered this very same rationale for a consent to search and found it was invalid. Now, in Hall, that was the court went on to say there was nothing else in the record to support the condition. The judge here never stated what the rationale was for imposing this condition. I asked the court that here also on this record, there's not sufficient information to justify the record. The crime does not, the condition. The crime does not involve a weapon. The crime does not involve drugs. There was no indication in the probation report that these were the reasons that the probation officers anticipated a need to supervise the defendant. Now, it is true in this record that Mr. Thomas has some remote cases involving a weapon and drugs, which respondent points out and asks the court to consider. But if you look at the full record, you'll see that Mr. Thomas's most recent criminal case before this case was in 2010. He did 1 year for a petty larceny. All the cases that the people asked the court to consider precede that. This particular crime does not involve drugs. It does not involve a weapon. It appears to be a dispute between two neighbors. It's really, Mr. Thomas at the time of this offense was a man in his early 40s. His prior offenses were when he was in his mid-20s. This is not a person who, for purposes of rehabilitation on this offense, needs to have the probation officers come into his home to do a search without a warrant. I would ask the court, the people have challenged whether or not the court should be considering it unpreserved. There are several cases, recent cases from this court, where you find that it survives both the appeal waiver and that it does not need to be preserved. Unless the court has questions on that, I would rest on my brief. Thank you.
Okay. Thank you very much, Ms. Everett. Counsel?
May it please the court, Larry Glasser for the respondent, the people of the state of New York. I would ask the court to find that this is precluded, first of all, by the defendant's waiver.
Come on, we've held that the waiver does not, that this claim survives the waiver. We've held that more than once.
Yes.
And so you want us to go back and reverse all our old cases, or our case, not even old.
Well,
okay, let's assume we're not going to do that. What's the next thing?
Well, I do believe, before I get to the merits of why this condition is warranted, one of the first cases that appellant cited was letter law, which is what this court has relied on in the past when it decided that the conditions of probation do survive a waiver because they go to the legality of the sentence. This court's never discussed that issue, and the third.
How about in People versus Arias? How about, I mean, yeah.
All those
let's assume that we're not going to reverse ourselves.
Well, in this case, appellant said there's no record to support the imposition of the condition, but that goes to the importance of the fact that the issue is not preserved by the defense. In this case, this has facts that are not present in many cases where this court has reviewed it, and that is, as counsel noted, the PSI requested this condition be imposed. Prior to imposing sentence, defense counsel acknowledged receiving the PSI, acknowledged reading the PSI, and then the court asked if the counsel would like to be heard on the matter of sentence, and the court just asked the court to impose the promised sentence, which was 2 years of probation.
Isn't that a standard request in pre-sentence investigation reports?
I don't believe it is, Your Honor. It's not necessarily, I mean, it's not truly unique in that it's tailored to this defendant, of course. The court has addressed this multiple times before, but I don't believe it's a standard request present in every probation case, to the best of my knowledge. But in any event, that's why this issue is subject to preservation, because had the defense counsel objected, the people could have argued why the condition was appropriate.
Okay, let's assume that we're not going to do reverse ourselves.
Okay.
How do you find this connected to rehabilitation of the defendant?
Okay, well, this defendant does have nearly 30 prior convictions. Many of them are for weapons possession, many are for drug possession.
But don't we have to look at the conviction that is right in front of us?
I don't believe so, Your Honor, because the issue of whether something's rehabilitative and the more generalized notions of the proper sentence in the case looks both at the crime and the offender.
So you're saying if he had a drug conviction from 25 years ago and now he was fair jumping, you could do as a condition of probation that you do warrantless searches for drugs and guns because of the 25-year-old conviction?
No, not at all, Your Honor. I would agree on those facts, that condition.
Well, what's the last conviction after this, before this one?
Your Honor, I would have to check, but the probation report did
Well, let's
note.
assume that it was 2010.
Right.
So we're talking about more than a decade.
The probation report did note that the defendant's history of criminal activity continued unabated. It did note that he did not fare well on parole supervision in the past, and that this is a condition that would help rehabilitate him because, as the Court of Appeals has said, this overall is a proper rehabilitative condition, a defendant knowing that they may
Then
be
wouldn't that
checked
be
up on.
true of every drug-addicted criminal? I mean, anyone who the probation found who had a drug problem would be subject to that same argument?
No, because again, 1 or 2 remote convictions for drugs years ago does not mean the defendant currently needs that level of supervision. But when you have over a dozen convictions for drugs and more for weapons possession and more for theft.
More than a decade ago.
I believe they were more recent than that. I don't want to represent that because I don't recall. I'm trying to look it up as I'm speaking to Your Honor. But again, the probation report noted that it was unabated and continued and would, for those reasons, I do submit it's a valid condition.
Thank you.
Thank you.
I would just remind the court that it's the court and not the probation department that decides what the appropriate conditions of probation are. The probation report may feel that his history was quote-unquote unabated. I don't know if that's the word that was used. But when you look at both the rap sheet and the probation report are in the file papers.
Are you able to tell us what we were asking Mr. Glasser, whether or not, how long ago it was since the last?
Yes, it was 2010. He was
That's what I
arrested in
thought.
2009, pled guilty in 2010 to petty larceny, got a year in jail. That was his most recent conviction. He does have, prior to that, when he was a young man, some drug convictions. He doesn't have,
That recent conviction was petty larceny, nothing involving
petty larceny.
any
He was
firearms.
he pled down to petty larceny. He doesn't have a slew of weapon possession. I wasn't sure whether to take what the respondent was saying. He does have even more remote. He was arrested for possession of weapons, but that is, I wouldn't say that he had more weapon possessions. He has primarily in the past drug offenses, but this particular case was a dispute between neighbors. There was no weapon involved. My client was punched the neighbor. He took his chain. There was the judge originally dismissed a number of the counts because the neighbor had overstated the value of what had happened. So there were some real questions about what actually happened between these two men. But this particular crime is not the sort of crime that this record supports a need to have a consent to search. And I would also note that in Hall, where this court found that the record wasn't adequate for consented search, where the probation asked for it for safety reasons, the court just modified the judgment. They didn't find that it needed to be preserved. And as the court knows, what happens is the defendant is asked to sit in the courtroom. He's given these. Just because something's in the report doesn't mean that he's there when the judge made the decision. Thank you.
Thank you. Thank you both. Next case for argument, People versus Tyler.
Good afternoon, Your Honors. I'm Benjamin Weiner from the Center for Appellate Litigation on behalf of appellant Taryn Tyler. The court here delegated a core non-ministerial duty to supervise the jury's deliberations to a court officer when it allowed the court officer to negotiate with the jurors over whether and for
Was
how
it a
much-
negotiation, or was it that simple act of the court officer going in and the jurors telling the court officer that they needed more time and then relaying that to the judge, who then relayed that to the attorneys?
It went beyond that, Your Honor. This was beyond mere message carrying. What the court officer told the court was that the court officer had been told, tell the jurors to stop deliberating. And he said, they want more time. I gave them 5 minutes. They actually wanted more. Of course, we don't have a record, which is part of the problem here of exactly what was said. But this suggests some back and forth and discretion on the part of the court officer, and not only to decide
The
to let
ultimate
them-
decision was the judge's decision about whether they had more time in consultation with the lawyers present. Is that
Well,
not correct?
No, Your Honor, not on this record, because after the court officer reported what he had done, the court delegated additional authority to the court officer. The court officer was told to inquire whether or not the jurors were quote unquote close to being done with their deliberations, and then based on their response, if in apparently the court officer's estimation they were close, to give them more time. These were incredibly sensitive matters that had to be supervised by the court because there was a real risk that whatever the court officer said, unsupervised by the judge, could coerce a verdict by failing to sufficiently convey to the jurors that they were not to abandon their firmly held beliefs about the case. And I would just note, for Your Honors, that the jurors rendered their verdict just 1 minute before the deadline that they were actually given. So that risk is very much present here.
That deadline was given to the jurors in consultation with defense counsel. Because the court conferred with counsel. Let's find out if they're close, and if they are, we can give them until 4:45.
Well,
and everybody agreed.
That's absolutely true, Your Honor. But People versus Ahmed is very, very clear that a defense lawyer simply cannot consent to this kind of delegation of authority to a court officer. What needed to happen in this case was the judge needed to call the jurors back. And if an inquiry was going to happen, for the judge to inquire where the jurors were in their deliberation, careful to do this in a way that respected the process and the sanctity of their deliberations, and not by a court officer.
What time did this exchange take place between the court officer, and the attorneys? Was it early in the day or was it late in the day?
It was late in the day, Your Honor.
So calling the jury in basically would have defeated the purpose of granting them the additional, 15, 20 minutes that they needed.
Well, again, I think, Your Honor, the case would look different if the court had said, okay, tell them that they get 5 more minutes, tell them that they get till 4:45.
But the court did. The court said, tell them that they have until 4:45.
The court did say that, but there was an additional very significant piece here, that the court asked the court officer to inquire into the jury's deliberations, to ask them whether they were close to being done, and then if and only if they were close, to give them more time.
How else is he going to find that?
Well, I think
Isn't this ministerial? Don't court officers go in often and get that information and bring it back?
this is absolutely not ministerial, Your Honor, because it's not mere exchange of information. The court officer isn't merely acting as a messenger here between the jury and the court. He's inquiring himself into the state of the jury's deliberations and making his own decisions about how long and whether or not to give them
How did he make his own decision?
He made his own decision because it was up to him whether, in his estimation, the jurors were close to being done.
It was what they relayed back to him about whether they were close.
Well, again, we have no idea what the jury actually said to the court officer, what question the court officer actually asked. That is precisely The problem in this case is this should have been done on the record, supervised by the court. And if the court didn't have time to do that before the end of the day, then it needed to bring the jurors back the following day. It couldn't delegate this to a court officer to do. I want to get to our right to counsel claim as well. Mr. Tyler was deprived of the aid of an expert attorney when, over the attorney's objection, Mr. Tyler's desire to peremptorily strike jurors was honored.
Well, don't we have testimony from the 440 hearing that explains that inartful way of putting it on the record, that it was not over the attorney's objection?
We do have that testimony, Your Honor, but that testimony simply cannot be squared with what the attorney said he was doing at the time he was making the strikes. The attorney was very clear. He said these
Let me
strikes—
just say, let me ask you this. The trial judge who did the trial also did the 440 hearing, right? And he heard the attorney's testimony and he found it credible, correct?
He
So
did.
the
Your
only
Honor.
way we could do the only way we could change that is to say that his credibility determination was wrong. The judge who held the trial and the 440 hearing, that's what you're asking us to do, correct?
That is what I'm asking you to do, and that is entirely justified on this record because of the lack of ambiguity and the clarity of what defense counsel said. He said, this is over my objection. There is simply no way to square that with his testimony later that he meant the opposite, that what he meant was actually Mr. Tyler and I agreed. If that's what—
Well, putting that aside, right, we have a very experienced trial attorney, correct?
That's true, Your Honor.
And during the course of his testimony at the 440 hearing, he explained his process for jury selection, correct?
He did, Your Honor.
And why shouldn't we give that weight? Why shouldn't we give that testimony weight?
Because we have such a clear record here that was made contemporaneously when the strikes were being made. Not years later at a 440 hearing, he said, this is over my objection. An experienced lawyer would not have said that.
But he explained to himself at the 440 hearing what he meant by over my objection.
But that explanation made no sense. There
Well,
would have
that's-
been no reason.
I mean, I understand it may not have been the best use of a phrase, and I think the trial attorney admitted that. But again, I have to reiterate what Justice Scarpoulis said. Here is the judge who had the trial, who also did the 440, who brought in the trial attorney, who had him on the stand, and he heard everything, and he made an evaluation in his 440 decision that he believed it, and we would have to be questioning the judge's finding of credibility.
And that should happen here because this isn't mere inartful phrasing. What he testified that he meant is the opposite of what he said. He testified we conferred and then we agreed. What he said is we conferred and this is over my objection. There is no ambiguity in that statement. There is no lack of clarity, and his subsequent testimony years later shouldn't be taken to have undermined what he clearly meant at the time.
Okay, let's hear from the other side, and you'll have a few minutes
Thank you, Your
of
Honor.
rebuttal. Thank you, counsel.
May it please the court, my name is Alice Wiseman. I represent the respondent. I'll start with the second issue. The entire record here, which obviously includes the hearing that defendant requested, the testimony at the hearing, the judge's factual and credibility findings, establishes that at no point did the defense attorney here simply abdicate his responsibility to make the ultimate decision about what jurors to strike. And he did explain, we all agreed it was inartful, but his point, he wanted to memorialize that initially they disagreed, and it's obvious he was going to keep those jurors. But then
he testified specifically that he would not have allowed the defendant to override his judgment.
Yes.
And he testified straight up, I would not have allowed the defendant to override my objection or agreement to a witness.
And he said if he wanted those, if he had wanted those jurors on the jury, he would not have stricken them.
But that being the case, don't you find it a little odd that the attorney says that he has conferred with his client, he is striking a particular juror, and then he says over my objection. as appellant's counsel here makes the point, that's a little odd. It sounds as if he's not in agreement with the defendant in this case, and he's just following the defendant's instructions to him, strike this juror.
Well, I think if that were in isolation, it might seem that way. But again, and look, I certainly know that as an attorney, I sometimes say things in a not good way.
But he said it more than once. He said it on more than one occasion, because he said it when he struck juror number 3, and then he said it again when he struck, I believe, juror number 13.
Correct.
Those 2 times he used the same wording.
That's correct, Judge. But both times, as he explained at the hearing, he was saying it to memorialize the same fact, which is that he initially disagreed with this, and then he changed his view after speaking with the defendant. Now, whether he wanted to memorialize that to make it clear to his client, and obviously his relationship with his client is important, that, hey, I'm listening to you, or for whatever reason. But at the hearing, he was very clear. He's a very experienced attorney. He's very thoughtful about jury selection. He's well aware the decision is his. And again, I would point out, if we look at People v. Colville, as long as the decision is ultimately the attorney's, he may just acquiesce in what his attorney, the defendant, wants. As long as it's not his independent judgment that this is wrong and harmful, the language the court used in Colville, this would have been okay if he had simply, after talking with his client, taking his views into account, acceded or acquiesced in what he said. In other words, what we have here are 2 jurors that, we discussed this in the brief. You can look on the record. There's nothing that makes them stand out as good jurors. There's some things that might make you think they're not good jurors for the defense. So if he doesn't have strong feelings about them, it's perfectly legitimate for him to take into account, gee, my client really doesn't want them. I don't see that they're needed here, so I'm going to exercise this challenge. That would not be a violation of defendant's right to counsel. Excuse my voice. With respect to the so-called improper delegation, what the judge told the court officer to go back in and say was, tell them if they are close, they can have until 4:45. That completely puts it in the lap of the jurors. The court officer isn't making a determination. He's saying, hey, if you're close, you can have until 4:45. They said, we'd like until 4:45. That was their decision. They were the ones who brought it up. And so there's no delicate thing going on here. So this is clearly, in neither case, a mode of proceedings error. It's not only not preserved, but actually agreed to by the defendant that this can happen. So,
Was there sufficient time to bring them into the jury room
I mean,
and ask them if they were close and if they required more time?
I mean, that would have certainly, as you mentioned, Your Honor, would have eaten up a not insubstantial. They had about half an hour, 20 minutes to half an hour left at this point. Any time, if the jury wants to keep deliberating, and if all parties are in agreement that it's fine to send in the court officer to just tell them, they can have that time.
Isn't that how it's commonly done in the trial court? I mean, unfortunately, there's a lot of time restrictions in our trial courts, and you have to stop or...
Late these days, so. Yeah, I think so, Your Honor. And again, this was just going in, reporting what the judge said with the agreement of all the parties. It was not the court officer being asked to make a determination or to sound them out about where they were and what the position was. Just telling them, if you think you're close and want more time, this is the amount of time you can have. And that is purely ministerial and obviously objected to, consented to, and therefore cannot provide a basis to overturn the jury's verdict. If there are no more questions, the people will rest on their brief. Thank you.
Thank you.
Two points, Your Honors. On the right to counsel, I think it's important to think about why an experienced attorney would be making this kind of record that counsel said he was making. Why is counsel making a record about this totally mundane thing that he and his client agree about whether or not to exercise the strike? And if he's going to make that record, why is he using the words "over my objection"? That doesn't convey at all to the client agreement and sort of a copacetic relationship. It conveys precisely the opposite, and that's because counsel meant precisely the opposite. He meant we do not agree. That's what he said, that's what he meant. As to the improper delegation, this wasn't just ministerial. Asking the jurors, are you close to deliberating?
They say, well, and they say yes or no. If they say no, then he said, we'll have to come back tomorrow.
Hopefully that's what happened, Your Honor, but this happened off the record and without the supervision of the court. That is precisely the point. This
When
was
you
a
say
sensitive
without the
area.
supervision of the court officer comes into the court and says, the jurors want more time. I told them I'd give them 5 minutes. And the judge and the lawyers talk. And the judge says to the court officer, go back and tell them they can have till 4:45. How is that not under the supervision of the judge?
Well, the court tells the court officer, tell them they can have till 4:45 if they're close. If they're close, and then they come back on the record and they have further discussion about whether or not the jurors are actually close. Again, we hope that this was a simple exchange. Are you close? Great. Take more time, but we don't know because this happened off the record.
I don't know, what do you think was off the record?
The discussion
What
of
the
whether-
jury said to each other about whether or not they were close?
What the court officer said to the jurors about whether they were close, what the jurors said
Do you
to
think the
court
court
officers?
officer had to bring a court reporter back into the jury room to say to the jury, you can have till 4:45 if you're close? You think that's a rule that you're required to do?
If the court is going to inquire into the status of the deliberations, that absolutely needs to happen on the record. And if there wasn't time to do that, the court had to simply put the case over until the next day. Time limitations are important, but they cannot override Mr. Tyler's right to have a trial that was supervised by a judge. Thank you, Your
Okay,
Honors.
thank you. Thank you both. The next case for argument is Cantor Fitzgerald.
Good afternoon, Your Honors. May it please the court. Ian Weiss for Appellant Avio. This appeal arises from Cantor's pursuit of a $2 million fee for nothing, based on a construction of the party's brokerage contract that violates binding precedent from the Court of Appeals. In its 2014 Morpheus decision, the Court of Appeals enshrined into New York law a special rule for construing brokerage contracts that had developed over decades in the appellate division. When properly construed pursuant to that rule, which we dub in our briefs the clear and express statement rule, the party's brokerage contract did not grant Cantor an exclusive right to sell. As a result, Cantor is not entitled to a fee for Avio's equity raise because Avio procured the equity raise on its own, independently, without using Cantor or any other broker.
In your view, does it matter whether the equity raise happened during the life of the contract or the tail?
No, it doesn't, Your Honor, because this contract did not grant an exclusive right to sell, period.
Period. So to the fact that it was in the tail, which is something the trial court was looking at, in your view, doesn't have any relevance to this point.
That's right, Your Honor. That's right.
So what do you make of the email exchange in June between Mr. Scythian and Mr. Hillard regarding precisely the agreement that if we procure some inside investor somehow decides to invest in us, then we got to pay Cantor $2 million?
Thank you, Your Honor. So first and foremost, the Morpheus Court expressly held that parallel evidence cannot affect the analysis of whether a broker has an exclusive right to sell. The broker in Morpheus leveraged, I believe, emails and other parallel evidence. The Court of Appeals unequivocally said that a broker only gets an exclusive right to sell if it is clearly and expressly stated in the contract, and parallel evidence is categorically irrelevant. Now, Your Honor, even setting that aside, the emails to which you're referring were sent around a year after the contract was formed, when Avio was objecting to the language in the contract and seeking to negotiate an amendment. The subject line of the email to which you're referring is EL amendment, engagement letter amendment. Avio is objecting to the language and seeking an amendment because the language is so unfair. So that language does not probe the parties' agreement at the time of formation. It shows the parties' disagreement around the time of termination.
Did Cantor Fitzgerald get any fee at all?
No, Your Honor, because Cantor Fitzgerald did not raise any money for Avio. The contract did not provide for any retainer. The contract was essentially pure contingency. Cantor had the right under the contract to terminate any time. So if at any time Cantor felt like the work wasn't worth its while, Cantor could terminate. But the contract allowed Cantor to try to earn a fee by raising capital for Avio. Cantor failed for, I believe, about 16 months. And so Avio terminated the contract, and Cantor didn't earn a fee and wasn't entitled to a fee and has not been paid a fee. Cantor claims, I want to clarify, Cantor does not allege in its complaint that it procured the equity raise. Cantor argues in its complaint that it's entitled to a $2 million fee, even if it had nothing to do with the equity raise, because the contract simply states that it's entitled to fees for Avio's transactions. But I need to emphasize this, Your Honors. The same was true in Morpheus, Altamira, and Silver.
Okay, yes. So, but I mean, if third-party broker came in, you wouldn't and got you that got the money. That would be an argument that they would have, that they had. It's only because you got the money yourself.
Exactly, Your Honors.
So it's not that unusual for someone to say, believe me, brokerage fees happen all the time because of that.
Exactly, Your Honors, and Cantor conflates those two very, very different things in its briefs. So to be perfectly clear, when a contract makes a broker an exclusive broker, the client cannot use a rival broker, and if it does, it owes the exclusive broker a fee. That is not the allegation here. That's not the facts here. The allegations have nothing to do with who procured the equity raise, and the facts in the discovery that did take place, there was some discovery in this case, there's absolutely nothing in the record to contradict Avio's testimony and evidence that it procured the equity raise independently. It does not owe a fee. Cantor did not earn a fee. We've got 4 precedents: the Morpheus case, Alta, Mirren, Silver Grove, with materially indistinguishable contracts. Cantor's holistic analysis, pointing to 4 different features of the contract together, are precisely what the Court of Appeals shut down in Morpheus. Cantor also points to Annex A, Section C of the contract in the additional provisions section. The one thing I just need to highlight very clearly, they don't accuse us of breaching our duty under that provision. That provision required notice from Avio to Cantor if Avio was contacted during Cantor's engagement. During Cantor's engagement. The equity raise happened after the engagement, so I just need to be very clear. No matter how much Cantor talks about that provision, it doesn't accuse us of breaching it. Finally, I'll just mention, because I'm sure Cantor will mention it, the recent GCA case. The defendants in that case did not raise the Morpheus doctrine or this entire clear and express statement rule. Morpheus remains binding, Mirren, Alta, and Silver Grove remain good law, and the court should follow that. The court should hold that Avio is entitled to summary judgment, or at the very least, hold that neither party is entitled to summary judgment. Okay. And with that, I'll reserve for rebuttal.
All right, you'll have 2 minutes on rebuttal. Thank you. Okay, good afternoon.
Good afternoon, Your Honors. May it please the court, Nirav Shah for Cantor Fitzgerald.
So how really can you get over the ruling in Morpheus that's been continued pretty, consistently, the same wording over and over again in the past 10 years?
Your Honor, I think Morpheus is our second best case. Morpheus says...
What's your first best case?
GCA Advisors is our best case, which I'll return to. But Morpheus says specifically, when it describes the language that is lacking in the Morpheus Advisory Agreement, it, in footnote 2, says, for example, it doesn't have X language that indicates that this is an exclusive right for sale. And one of the provisions that it says the Morpheus contract lacks is a provision that states that all inquiries or offers to the client have to be sent through the investment banker. The second point about Morpheus that makes it a good case for us is the reason the Morpheus court thought that...
Just tell me where in the agreement you think it says that there is express language excluding, which is required, this is what Morpheus requires, express language excluding a direct conveyance by Avio. What language in the agreement are you relying on?
The same language that the
Read it out. Tell me what you think says that, read to me the provision that says that I get paid if you convey.
It's Annex A, Section C, Your Honor, which is the same as the Morpheus contract. In addition, in the event that
Well, okay, so there, so that's why I'm wondering why you think Morpheus is so good for you.
the Morpheus case, not the Morpheus contract.
Okay.
This is from footnote 2, where the Court of
I'm
Appeals.
asking you, read the language that you think says expressly, I will get paid if you, Avio, get the money yourself.
That's in Section 6. That's the tail fee.
Read it. Tell me what it says. No, the tail is not that. It's not the tail. It's an expression in the contract that says, I get paid even if you bring the money in yourself. Just read me what you think says that.
It's the same provision that the Morpheus court said.
Okay.
In addition, in the event that during the period of the engagement of CF & Co. hereunder, the company or any of its representatives are contacted by or on behalf of any party concerning the possibility of the transaction, the company will promptly so inform CF & Co. in order that CF & Co. can evaluate such party and its interests and assist the company in any subsequent discussion.
You think that that says if I have to, you get to evaluate me? If I put the money in, I have to let you.
The contract also says that, Justice Garcia.
Okay.
The contract specifically says that an acquirer, for purposes of a transaction, is not simply outside investors who are procured. It expressly states that among the acquirers are the insider parties, are parties who are related
Where does it
parties.
say that you'll expressly be paid? That you're referencing a valuation of potential investors, but nothing about definitively you will be paid.
Your Honor, it says that if there is a transaction, you will be paid during the 9 months of the tail in Section 6.
That's for a transaction that is
Already
in progress before the agreement ends.
Well, so first of all, and this relates to the defendant's motion for summary judgment, the transaction, the raise that took place was already in progress before the contract was terminated. We put in evidence that clearly indicated that. That's at record 418, where there is a discussion between Cantor and the ultimate investors in this insider raise prior to the termination of an insider raise. And
Why doesn't the agreement say it is understood by the parties that Cantor Fitzgerald will get paid if Avio itself puts in the money for the transaction? Does that say that anywhere in the agreement?
In those words, no, but the Morpheus
Any express words like that in the agreement?
Yes, Your Honor. The same.
Just that if anybody comes to us, we'll send them to you? You think that that means that if we decide to put money in, we have to go to you and say, evaluate us?
That's what the Morpheus decision says, Your Honor. That's what footnote 2 says.
So you were talking about this footnote. I want this footnote 2, which I have in front of me. So tell me, how do you think that footnote 2 applies to the contract that we have here in this case? What part of the contract sort of fits into that?
So footnote 2's reference is specifically to language that says, quote, it says the language that is lacking in this contract that would have created and by the way, it's not just an express statement, it's or a necessary implication. Language that could create a necessary implication is language that says that, quote, that the client must, quote, refer all inquiries or offers to the client. That's the last line of that footnote, Your Honor.
Okay.
So banks and advisors are entitled to rely on a Court of Appeals ruling like this. This is language that is exactly like what the Court of Appeals said creates this necessary implication. And the fact that Cantor didn't procure this investor, at any point in this engagement, if Cantor had not procured the investor and it was an inside investor, the definition of acquirer and the definition of transaction makes clear that is a compensable event. And the last thing I want to get to, Justice Scarpullo, you started by asking, is there a difference between the tail and the actual engagement period? And the GCA advisor's decision, which I think is right, and I don't think that we're supposed to assume that the First Department doesn't understand the law here. The presiding justice for GCA advisors is the same justice who is a presiding justice for their favorite case, the Silver Grove case. That decision says specifically that tail fees are different and that the brokerage agreements do not necessarily apply to them. It says specifically, the broker cases cited by defendant are inapposite.
That doesn't overturn Morpheus or even affect what Morpheus says.
It's consistent.
You can't say that the agreement, I get the right to a fee during the tail period, even though it doesn't say expressly in the contract that the other party can't do the transaction themselves. That GCA doesn't stand for that at all.
It stands for the idea that a tail provision like this is not subject to brokerage, the line of precedents that have been formed in brokerage law, and that it is both consistent and industry standard in the world of investment banking that if there is a tail and it doesn't say that you have to procure the investor to get the fee, then that is not a provision that courts ought to read into this. If we were not talking about Morpheus as
So you're saying you get better rights in the tail than you do in the contract?
You could, Your Honor, because
I don't
during
think
the contract,
I do not agree with that as stated.
during the contract, Your Honor, you're dealing with all of the actual work that's being done, and if you look at this specific tail, it says Cantor shall have, in effect, a right of first refusal. You can come to Cantor, and we'll do all of that work during the tail, and if we say no, you don't have to pay us. And that, I think, it doesn't just imply, it necessarily implies, to use Morpheus's words, that in other cases, including this case, a fee would be owed. But what I want to leave the court with...
Would they need Cantor for this? Weren't they putting in their own money? Why would they need Cantor? Why would they go to you during that?
I think for the same reason that in the initial engagement, the parties agreed that an acquirer may in fact be insiders, may in fact be related parties, because the work that Cantor did isn't just finding an investor, it's modeling, it's marketing, it's getting the financials prepared for an actual raise, all of which there's no dispute that Cantor actually did. And so this is how banks get paid when they do that kind of work on a transaction like this. I just want to end with the point that to the extent the court disagrees with this interpretation, then the appropriate result is to simply remand so that Cantor can actually prove based on the facts. This was a raise that was in progress at the time that it was terminated and therefore is subject to the tail, irrespective of Morpheus.
Okay, thank you. Counsel, you have 2 minutes.
Your Honors, Cantor's counsel didn't ask for a remand for further discovery in their brief to this court. They didn't argue that any such discovery would be necessary. I want to focus on the tail point and the Annex A Section C point. Your Honor, 3 of the cases that we cite apply the clear and express statement rule specifically to tail provisions. In Silver Grove, one of the broker's arguments was that it could be entitled to a tail fee for a tail period transaction, and the court analyzed that under the clear and express statement rule, just like it would analyze any other case. The Second Department in New York Commercial Realty analyzed a contract where the parties agreed there was a grant of an exclusive right to sell for the engagement period, but the Second Department held that the contract's tail provision did not extend that right into the tail period. So that was a case where there was exclusive right to sell in the engagement period, but not the tail period. And that's especially important given Cantor's Annex A Section C argument. Annex A Section C put a duty on Avio that was expressly cabined to the engagement period. It would make no sense to require Avio to keep Cantor in the loop after it terminated Cantor's contract. So at the absolute most, the Annex A Section C could be interpreted to create an exclusive right to sell cabined to the engagement period, not to the tail period. And I also want to flag that the Second Circuit's decision in Dominic and Dickerman had a paragraph specifically addressing a tail provision and holding subject to the same clear and express statement rule as anything else. So if there are no further questions, I'll just ask the court again. We would like summary judgment in our favor. We believe that it's ripe. There's no genuine issue of fact. Cantor did not procure the equity raise. It would require a direct and proximate link, and there's no link. There's no genuine issue. We should get summary judgment, at the very least remand. Thank you.
Thank you. Thank you both. Next case is People versus Pointer.
Good afternoon. My name is Seidler, and I represent Trenton Pointer, who was a fellow who lived in Virginia, committed no crime in Virginia, was never charged with a crime in Virginia by the state of Virginia or any federal authorities, who was charged with a crime in New York because a guy named Davis would travel to Virginia and purchase firearms from Pointer, which is not a crime in Virginia. Background checks are not required, or were not required prior to April 2020 in Virginia. I think the people concede that. So then Davis would take the guns he bought, and come up to New York and sell them to an undercover police officer. So on some far-fetched acting in concert theory, and based on listening to some tape recordings that were part of a wiretap that was up for part of the investigation, and then
So
taking
you say
normal.
far-fetched, right? But isn't it the law in New York State that an individual can be brought to the jurisdiction in New York based on the acts of their accomplice?
Well, if there's some knowledge of it, right? I mean, you have to have some knowledge.
You asking me questions?
Well, it's a rhetorical question.
Oh, okay.
What I'm saying is, yeah, if you commit a crime in Virginia and somebody commits a separate crime in New York, you're not responsible for the crime that was committed in New York.
What about the straw purchaser writing out a New York address for the shipment of the gun?
The straw, well, that first off, that receipt was never produced in evidence. There was no such receipt. And I am not aware that the straw purchaser put down a New York address as the ultimate location for the weapon or the two weapons that she purchased in Virginia. I think the straw purchaser said that Pointer had mentioned that the location was going to go to New York. But, and I don't mean to be harsh, but this witness had every witness infirmity imaginable, including hallucinations, hearing voices. She couldn't even come to court unless she was accompanied by her caregiver, her mother, and she testified at the second trial, not the first trial. But for Davis to come to pick up guns in Virginia and go back to New York and buy them from Pointer, that's not a crime in Virginia.
So you're saying that Mr. Pointer could use, I mean, we know that he used this lady as a straw purchaser, and she says that the gun was going to be sent to New York because he told her that, and that it was going to go to this gentleman Davis. And then you have, as you said, the wiretaps where he's recorded speaking to Davis, talking about guns, talking about guns that are going to be sold in New York in the street, uptown, right?
I disagree with that, Your Honor. There was talk about money being sent to New York.
And there was money sent every time a gun was given to Davis or Davis sold to the undercover, then somehow money appeared in Mr. Pointer's account, either his or his wife's, and then so all of that, and he knowing that these guns are being sold in New York, that's not sufficient for New York to acquire jurisdiction?
It would be if he knew the guns were being sold in New York, and that's my argument. He didn't.
He did.
But if I could just, the tail that wags the dog here really is count 4. That's the count that got Pointer 13 years in jail. And that count, as charged by the grand jury, specifically gave the time frame for the sale of the 5 weapons as 7 months. That indictment was never read to the jury. As part of the judge's charge to the jury, he read them the statute that crime generally falls under, not the wording of the charge. And that expanded the time frame by 5 months. And the problem for Pointer is that one of the 7 gun transactions charged took place in that 5-month period of time. And there was no juror questionnaire here. We don't know what sales the jury relied upon to come up with a total of 5, but the April 19th sale was not within anywhere close into the time frame charged by the grand jury, or it was put into the time frame by the judge in his charge to the jury.
All right, we'll deal with that and whatever other issues during rebuttal. Thank you. Counsel?
Good afternoon, Your Honors. May it please the court, Sylvia Wertheimer for respondent.
Can you put the mic down a little bit?
Sylvia, is this better?
Yes.
Sylvia Wertheimer for respondent. Just with respect to the constructive amendment claim, I would note first, it's unpreserved, and it's actually waived because the defense counsel on summation agreed that the April 19th sale was one of the sales that could be considered with respect to the second-degree sale count. In addition, the defendant's attorney says, you don't know what sales the jury relied on. We do know that the jury convicted this defendant of selling 8 guns. So that was more than the statutory threshold of 5 guns.
So it didn't necessarily rely on that particular sale, did it?
Well, but the jury convicted defendant separately. There was a separate charge charging the jury with, charging defendant with that sale. So the jury did convict him of that. This was not, if anything, this was a variance, and it's this kind of unpreserved claim that really, that would have been easily addressed if he had said, oh, please read the time period from the, but he didn't do that. And in fact, the defense counsel agreed that the April 19th gun sale was one that could be considered. With respect to the jurisdiction claim, I mean, the evidence here was just.
Didn't we just, I think I just sat on a panel of one of defendant's co-defendant where we found the court did have jurisdiction.
Yes, Jenkins.
Right?
And this, I would submit that the evidence here is even stronger than in Jenkins, because here we have Wyatt, who acted as a straw purchaser. Wyatt didn't testify at the first trial, I think because people didn't even know about her until afterwards. But Wyatt gave very credible testimony. The jury heard all about her background. They were entitled to consider her. She established beyond any question that defendant was getting people to buy guns for him.
And the guns that she bought for him were the guns that were found in New York.
Were found in New
with
York.
Davis, right?
And I mean, in his reply brief, defendant says something about that the inference is that Wyatt somehow sold the guns to Davis. There's not a scintilla of evidence that Wyatt knew or ever spoke to Davis.
The jury made credibility determinations.
And the credibility, her testimony alone establishes knowledge of New York required for jurisdiction. And in addition, we have the telephone calls, which in context, and keeping in mind that they are being careful in these conversations, certainly conveys that defendant knew that the ultimate purchaser who was providing the money was based in Manhattan.
Are any financial records also available for the jury to examine?
There were records of wire transfers that were before the jury. And so those were, I'm not sure that there was for every single transaction, but there were wire transfers. But it's clear that this undercover, the purchaser is an undercover, and he testified to every transaction. And in this particular, in the February 23rd phone conversation, they're talking about a transaction, and Davis tells defendant, oh, the man, clearly the ultimate purchaser, can't go to the bank to get money because there was a crane collapse. He didn't use a crane collapse. Something happened in Manhattan and he can't get to the bank. I mean, that made it clear as day that the purchaser is in New York. I just want to say one word about the Molyneux claim, only because defendant raises it for the first time in the reply brief, so we never got an opportunity to even address it. Very quickly, that claim is unpreserved, and it's utterly bogus. The other gun transactions that came into evidence were overt acts that were named in the conspiracy count against defendant. They were relevant for that reason. They were also relevant to show the large scope of this gun trafficking conspiracy. And really, they weren't Molyneux at all, because they weren't even defendant's prior bad acts. So it's an utterly bogus, unpreserved claim. If there are no other questions, the people rest on their brief and ask that the judgment be affirmed. Thank you.
Thank you.
I have 2 minutes, so I'll hurry. Number one, the 2 guns that Wyatt purchased in Virginia and ended up in New York, it's not dispositive. It's not a crime to resell a gun in Virginia. And if it ends up in New York, that doesn't prove that the seller in Virginia knew that it was going to end up in New York so as to be held responsible for criminal conduct in New York. And as to the constructive amendment of the indictment, the people in their brief said that there were 7 guns that the jury could consider in count 5, not 8. We don't know which guns they found as sufficient to make up the 5. And, excuse me, and clearly the April 19th gun was not part of the time frame charged by the grand jury, and it became relevant in the case because it was separately charged as an individual sale in count 117. So it became an element in the case, but it was not an element in anything that the grand jury charged and asked the jury to consider. And it was only because the judge gave an expansive view of this time frame that they were able to do it. And it doesn't matter that they convicted him they only needed to convict him for 5 of the 7. Well, we don't know if the 7th gun, the April 19th gun, was in fact a gun that the jury convicted him of. Thank you.
Thank you. Thank you both. The next case for argument is Deer Park versus Nationstar Mortgage. Justice Michael is recused from that case. If there were to be a tie, we would vouch someone in according to our rules. Good afternoon.
Good afternoon, Your Honors. I'm Charles Rothfeld and Mayor Brown, appearing on behalf of the defendants. In this case, the defendants exercised their undisputed contractual right to acquire outstanding mortgage loans in a mortgage securitization in return for 100% of the unpaid principal balance. The plaintiffs contend that this amount, the principal balance, includes foreborn principal that was removed from the amortization schedule that was no longer paying interest. They are wrong for separate reasons of federal law and of state law. And I'll focus this afternoon on the federal question. The federal rules that govern here were the product of the Great Recession. In the wake of the Great Recession, Congress and the Treasury Department created mechanisms for the modification of mortgage loans. The goal was to make it possible for servicers to modify loans in a way that would keep homeowners in their homes, to encourage servicers to do that. And in particular, Congress, in the Emergency Economic Stabilization Act, provided as an express federal statutory safe harbor, provided that mortgage servicers would not be liable, they shall not be liable, for taking steps to effectuate the mortgage modifications as approved by the Treasury guidelines, the so-called HAMP guidelines. Congress also, in the EESA, provided that the HAMP guidelines are incorporated as a matter of standard industry practice. and as to all state and federal laws, and therefore presumptively they effectively have become kind of read into the mortgage contracts. The HAMP rules that govern here are the ones that deal specifically with foreborn principle as applied in securitization vehicles. That's expressly how they were addressed by Congress, and by the Treasury Department, and Treasury could not have been clearer and more emphatic on how it wanted foreborn principle to be addressed. It said that foreborn principle must be treated as realized loss, and it said this repeatedly. It said it in the widest range of contexts. It said specifically that servicers must report foreborn principle as realized loss to the trustee. It said the trustee must allocate foreborn principle as realized loss.
These were guidelines, right? I mean, there was no statute, nothing was enacted. These were guidelines put forward by Treasury, is that it?
These are guidelines, but they were specifically authorized by Congress, which directed Treasury to put in place mechanisms for the modification of loans. And so in the EESA, the Emergency Economic Stabilization Act, Congress specifically provided this safe harbor that referred directly and expressly to the HAMP guidelines. It said the guidelines as the rules as put in place, as recognized by Treasury, are what kind of effectuate the safe harbor. And so
Didn't you commence an Article 77 proceeding just on this particular question? On whether or not the interest had to be included? Or the deferred principal, and Judge Borak ruled, yes, it does, and you didn't appeal from that, right?
Well, he did rule that.
He did?
He was clearly...
And you didn't appeal from that ruling?
Well, we didn't appeal from that, Your Honor, because this case was already on appeal, and as we kind of explained in our briefs, the fact that we didn't appeal, I mean, our opponents argue that...
Well, your adversary is arguing that you're collaterally stopped now from making this argument.
They do.
You had an adverse decision. You could have appealed it directly.
They do make that argument, Your Honor, and they are wrong for two reasons. One is, I think it's black letter law in New York and everywhere that legal determinations, legal questions are not subject to collateral estoppel, and question of the application and preemptive force of HAMP is a legal question, and so collateral estoppel could not apply. As we also explained, we had no incentive to appeal because there was no indication that the defendants here had any interest in actually effectuating a cleanup call in the Article 77, as to the Article 77 trusts. So for that reason, separately, a collateral estoppel would not apply. And with all respect to Justice Borak, we think that he was clearly wrong in the Article 77. We think it's absolutely clear from the HAMP guidelines and from the federal statute that incorporates the HAMP guideline standards, preemptively, that the clear intent was that foreborn principle has been lost. Again,
Can you address the no action clause issue?
Certainly, Your Honor. I should say kind of preliminarily, we think the court doesn't have to reach that because I think the federal question resolves this case, and so the state law...
We generally are a state law court, right? We like our state law questions better than our federal law questions.
Well, but I mean, federal law is...
So why don't you start with the no action clause?
Certainly, right. We think clearly that they do not satisfy the no action clause, and we kind of run through the elements in the briefs. I mean, there are 5 separate factors that must be ticked off for no action purposes, and we think none of them were. I'll just focus here. It absolutely is required that there be a request made to the trustee to bring suit. It absolutely is required.
The trustee is not the person who's liquidating. I mean, is not the person who's getting the money, right?
Exactly
so
right.
It's not one of the cases where I say I have to sue myself. I can't sue myself, right? That's a different case.
Precisely right. There's no futility here. In fact,
Right.
I mean, the trustee initiated Article 77 because they wanted guidance. I mean, they wanted to know what they should do in these circumstances. And so they did not ask the trustee to sue. They did not guarantee indemnification to the trustee. I mean, they point to letters that they say they sent to the trustee. If you actually look at the letters, they don't.
Which we did, and we saw that. So, I mean, if we were to agree with you that there was no such request and they did not comply with the terms of the no action clause, doesn't that sort of end the case right away?
That
Not
would,
having to
yes.
go into these other questions?
I think they fail for a zillion different reasons, Your Honor, and so it doesn't really matter which one the court picks. We focused on the federal standard because we thought that was clear. We think I should say they're all clear, and the federal standard is kind of a significant issue that we think is pretty straightforwardly presented by the Treasury Department rules, and this court in its very recent Wells Fargo decision, we think addressed the HAMP standards that apply here directly, and we think applied them in a way which should be dispositive in this case. And if I may, I'll reserve the remaining time.
Okay, so you have a few minutes for rebuttal. We'll hear from
Thank you
the
so
other
much.
side. Thank you very much.
Thank you, Justice Kapnick. Sam Lieberman for Respondents Deer Park and STS. May it please the court. HAMP did not grant a $7 billion servicer windfall in a footnote. In fact, what HAMP actually says is that servicers must act, quote, in accordance with existing servicing agreements at A471, A492. And here, the agreement is clear on its face that the termination price must include 100% of the unpaid principal balance of each mortgage loan. 100% of the unpaid principal balance of each mortgage loan includes the unpaid deferred principal balance. Why? Because that deferred balance is fully due and payable from the borrower. And it's delayed.
Isn't it written down?
What's that?
Isn't it written down?
It's owed by the borrower. No, the borrower has to pay it. Something
Well,
I
I'm
think they've
talking
omitted.
about for the owner writes it down, right?
No, the owner, the borrower has to pay the loan.
Right, but
So
I'm
what- so
asking
they're
you,
referring to-
how does the RMBS owner treat it during that term?
So there's a
They
footnote in
take
the
a
HAMP
loss,
guidance.
right? They take a loss on
For
it.
purposes of calculating distributions, it's treated as a realized loss. But Justice Scarpula, what's happening here is
Why should we treat it any differently when they sell the asset?
because there's specific language in the trust that uses loan accounting and not trust accounting. When there's a termination of a trust, it's a once-in-a-lifetime event. When the assets of the trust are being sold out of the trust, you're going outside of the trust and you're selling property for property. The trust has an ownership right to be paid the deferred principal. And there's no dispute that when deferred principal is paid by the borrower, it's paid into the trust and it's distributed to all the investors.
But that's my whole point. Isn't that written down? What borrower is
And
going
it
to
gets
pay the
written
money?
back up. The trust continues to have a property ownership interest in the money that gets paid. And the question is, in the termination price, will the trust investors get paid back for that? And HAMP, in fact, uses the words unpaid principal balance. The footnote they cite does not.
So even if the loans are so bad that you get to write them down, you're saying that on termination, the owner has to pay full value?
Yes, but in fact, Justice Scarpula, I would ask you to look
Wow,
at the 90%.
that doesn't seem like a great deal for anybody who would take advantage of the HAMP
In
program,
fact, Justice
does it?
Scarpula, if you actually have paid attention to the real estate market, NRZ has flipped this at 100 cents on the dollar. And this is what we want to prove through our case. We found evidence that they've sold it for more than par in some instances. These are valuable assets, and that's the reason that when you are cutting off the rights of investors, the investors are not getting, you could have written in the agreement, you should get paid the certificate principal balance. That's the value of the security, the write-down. But no, it's the unpaid principal balance of the mortgage loan. And I would say
Can you
have to.
address the no action clause, please?
Yes. We, on March 30th, asked the trustee to take action. On August 5th, we asked the trustee to take action. And most
Did
importantly,
you ask them to bring a lawsuit?
on A714, we talk about on September 2nd, we asked them to include.
Is that after
this.
the lawsuit?
No,
is-
this was actually 75 days before filing the case. So
Yeah.
on September 2nd, we actually asked them to include this case in the Article 77. And
That's
the
a
trustee-
different
That's a
thing,
litigation.
right? That's not this. And did you
We asked
ask
them,
to,
and that's
did you
included
tell
as a
them you would,
litigation.
did you tell them you'd indemnify them?
Yes, we did. We referred
Where?
to Section
Show me.
6.024.
No. That, I mean, no. Where in the agreement, where did you say, and we will indemnify you?
We did We referred to indemnification.
Read
on
it to
that.
me.
Okay, well, at A714, we said we will provide reasonable indemnification. Now, this was February 2023, after the action started.
Right, so let's not talk about, I'm saying before there are two things that are required in the no action clause. You have to say, you must bring litigation, right? And you must agree to indemnify me. I'm asking you, prior to the litigation being brought, where in any of those letters do you say straight out, and we will indemnify you?
We referred to an indemnification provision in the agreement.
That's not, just read it to
Okay,
me.
well,
Where does it say? I
think
could say,
The
sure.
question is there a Rule 9B? Is there a Rule 9B requirement with respect to a no action clause where
I think
you
there is
specifically have
definitely,
to plead it?
yeah.
I will.
I
but
think
the trustee
no
here
action
has
clauses
confirmed
are
it would not
definitely.
take action.
Wait. Let her finish her question, please.
No action clauses are construed strictly. There's no doubt about it. So again, you tell me where in any of your pre-litigation notices you said, and we will indemnify you. Because why should the trustee take on a potentially $1 million of legal fees if it thinks it's going to lose?
Your Honor, in fact, so look, our answer is that we referred to 6.024.
That's
and then
it?
afterwards, we confirmed.
Okay.
But I would point to something else. You pointed out a very good point, that they're strictly construed, but they're also construed by their terms. And what the no action clause here states is that you can't bring an action solely by your status as a certificate holder without asking the trustee. But we are bringing a direct action. And under the Ellington credit case, the Southern District of New York has said that where you have unique damages and you're bringing a direct action, you don't have to comply with the no action clause.
We've never said that in this court. We've never said that in the state of New York, right?
Well, I'm saying
And the
by its
state of
terms.
Delaware has never said that.
Well, Delaware has said that when someone's taking action solely by their status as a stockholder, that is referring to a derivative case. Here we have unique action.
This is not a derivative case.
Here we have, this is not, exactly. They're saying when you refer to someone solely on the basis of a certificate holder, that's a derivative claim. Here we're bringing a direct claim. We're suing for our unique damages as the Class X certificate holder. No other certificate holder would have an actual issue with respect to this because they all got paid. We're the only ones who didn't. And if what you're saying is we just have to go back and refile, then we would do that, but it's obvious that the trustee wouldn't act here. We have 100% of the damages here. This is a direct action. And in any termination, there's only going to be certain certificates that are damaged. It's just going to be the people at the end. There's $3 million at the end. This is a consummate direct action.
Why
we don't
wouldn't
think the
they-
clause applies here.
Why wouldn't they act? Why you're saying it's obvious the trustee
Well, yes,
would not act?
and
Why-
let's get to
why
the,
so?
the trustee actually has liability here. And the trustee has liability because the trustee conducts the sale of the trust assets. So that's a classic conflict of interest because the trustee has been accused and literally would be involved in the wrongdoing. And we refer to the Second Circuit Commerce Bank decision, which held that where the trustee is accused of wrongdoing in other actions, that creates a conflict of interest, which excuses the clause. We point to the pleadings in the cleanup call Article 77 hearing, paragraph 55, where the trustee said that it was threatened with litigation from investors and that if it took action, it would risk liability. So we ask you to consider that. Isn't that an issue? The trustee acted in violation of the plain terms of the agreement. We ask you to keep that under consideration.
Thank you.
Okay, thank you for your time.
Thank you, Your Honor. Just a couple of very
I
quick
want to
points.
ask you about counsel's point that you're actually benefiting incredibly from using the HAMP system or HAMP deductions because now you're selling the property at 100 cents on the dollar and you're not putting that 100 cents on the dollar into the pool for the RMBS trustee holders, trust certificate holders. What do you say to that? Is that true?
I say that, the record tells us nothing about that, and so I really can't tell you authoritatively what has taken place outside of the record. What I can tell you for sure is that HAMP is absolutely clear, and Treasury...
So if we sent this back for a trial, there's a possibility that the owner, NRZ, is giving you nothing and taking 100%, 100 cents on the dollar on those bad loans?
I'm saying...
Is that a possibility?
It's certainly it's possible that that NRZ can profit from the loans if the loans actually turn out to be valuable. And the fact is we don't know whether they are or not. The reason that HAMP was put in place in the first place was because the expectation was that forborne principal, in fact, was not going to be repaid. And that's why Treasury was very, very clear. It wanted to give the servicers assurance that whatever happened down the road, they were not going to be faced liability for facing the HAMP, for effectuating the HAMP requirements. And so,
And you think that and part of that is they get a boon and a windfall if it turns out that the market turns out to be pretty good 10 years down the line?
well, I point out, I mean, during the entire life of the trust, the forborne principal was excluded from principal balance for all the reasons that principal balance was relevant during that time, for the payment of principal and interest to the certificate holders, for the calculation of the servicer's fees. All during that time, the forborne principal was removed from the principal balance.
That's what I'm asking you. I'm asking you whether you think the HAMP program intended that you get the bonus at the end of the day not you, the trustee, but the owner gets the bonus, or the NRZ, is it?
NRZ.
NRZ gets the money as opposed to the people who've been risking the whole time.
Well, I think that Treasury was very clear that it wanted to tell servicers at
that was an okay result?
That whatever happened at the end of the day, they should be prepared to engage in loan modifications, including the use of principal forbearance, knowing that at the end of the day, if they then effectuated the terms of the trust as the trust is written and as the HAMP requires, they would not be subject to liability. Because if they did not get that guarantee, what they would likely have done is simply not modify the loans at all. They would have foreclosed the loans back in the day, because they were been concerned that 15 years later, when the trust is over and they are terminating it pursuant to the trust term, they're going to find themselves faced with litigation and liability, just as they are being faced.
So they could have done mortgage foreclosures way back when and got rid of all these assets, and we would be in the same.
And we would be in far worse position, and the homeowners would have been in far worse position. That is exactly why Treasury put the program in place, and why they wanted to guarantee that the servicers would not face liability in precisely this circumstance. And I just, if I very quickly point out on the no action clause, which Justice Scarpilla had raised up, I think there is no answer. The plain language of the letters that were sent do not address what is required by the clause, and the clause says that it applies to any claim under this agreement. That clearly is what's going on here. So if there are no further questions.
Thank you.
Thank you so
Thank
much,
you
Your Honor.
both very much. Estate of Chung Lee versus Lee.
Good afternoon.
Good afternoon.
May it please the court, my name is Eli Feit of Hella, Horowitz & Feit, and we represent the appellants on this appeal. As the court obviously knows, this is an appeal from an order of the IAS court that denied my client's motion to dismiss the complaint on the grounds that the complaint was barred by the statute of limitations, res judicata, collateral estoppel, and three other grounds which we're not advancing on this appeal. On this appeal, we address the statute of limitations, res judicata, and judicial estoppel as grounds for reversal. Let me begin by addressing the statute of limitations. Everybody knows that the key to the issue on statute of limitations is the accrual date. In this case, the accrual date, I don't think there's any dispute about it, is June 25, 2007. Now, how do I get that date? Why is
Isn't that exactly the whole dispute? You're saying that the accrual date is 2007, and your adversary is saying it's 2016?
My adversary is saying 2016.
So there's a dispute there,
But there shouldn't be a dispute, and I'll explain to the court why there shouldn't be a dispute. There shouldn't be a dispute because, number one, the appellate division on two separate appeals recognized the accrual date as June 25, 2007. But even more than that, the plaintiff respondent, in a brief to the appellate division, and that's on the record, page 172, said that the surrogate, in its decision, got the accrual date correct. And it told the appellate division, we agree that the accrual date should be June 25, 2007.
Counsel, this is a declaratory action, right? So in terms of the accrual date, we're looking at the accrual date from when there's an interest declared. In this case, when was that?
Yeah, the issue to declare and all the underlying facts and the entire dispute arose actually in 2004 and 2005. And what happened was the decedent, Chung Lee, filed in a related case, filed a statutory declaration and a letter of authorization, and he says, I own 20% of these companies, I'm the owner.
But the ownership interest wasn't actually declared until what date?
The owner, Your Honor, correct. What happened was the surrogates court made a decision on a petition that was brought by Chung Lee's estate. That petition requested a declaratory judgment, and if you look at the petition, specifically, it says it asks for a declaratory judgment. In fact, in the current complaint, on paragraph 41, and it's in the record at pages 34 and 35, in this current complaint, the estate specifically characterizes what the petition requested, and I want to read that to you. It says, paragraph 41 of the current complaint, on June 25, 2010, plaintiff commenced a special proceeding pursuant to SCPA 2103 in the Surrogates Court of the State of New York, County of Queens, entitled The Matter of State of Chung Lee, for discovery, delivery of property, and here's the clincher, and a declaration of the estate's ownership interest in the New York companies.
So wasn't there a finding at some time that the estate of Chung Lee had an interest, but no determination as to what percentage interest that was?
Well, the surrogate made that decision.
Right, and didn't that get affirmed?
And that got affirmed on appeal.
Right.
And doesn't the statute, doesn't the time begin to accrue from then?
It does not, because the underlying dispute, as I said, we lost on that, but we're taking June 2507. I'm bound by that, because I argued that 2004, 2005 was really the starting date for this dispute based on the statutory declaration, a prior lawsuit, so on and so forth. But I can't dispute that because the appellate division made a finding, said June 25.
So as of today, how much does the estate own? How much does your client's estate own? And how much do the other three children own?
I don't think that's the issue before the court.
I'm asking you, you said that was determined in the other action.
No, the determination was the surrogate decided.
That there was something there, that the petitioner
Right,
there
an
had
ownership
some
interest.
interest sufficient enough to require your client to turn over documents, right?
To turn over.
So now the question is, how much is everybody's interest?
I don't
That
think-
wasn't because your client took the position in the other case that she had the whole ball of wax and nobody else had anything, correct?
But I don't think that determining the specific interest, they asked for a specific interest already. How many bites at the apple are you supposed to get?
I think
But
because
it hasn't been determined.
right, and the appellate court said not in this proceeding. This is only for documents. Sure, you've got some interest,
No,
but here's the documents, and we're not doing anything else.
What the appellate court said was, and that they affirmed based on the fact that what the surrogate said, that there was an ownership interest. That was the determination.
Isn't that the first time anyone said That not, your client didn't own the whole ball of wax,
if-
that somebody else
Your
had
Honor,
it?
if the, if the respondent wasn't happy with that decision, his remedy was to take an appeal. He didn't take an appeal. He never appealed. In other words, he asked for a declaratory judgment. I just read it in the complaint that he's filed here. He said that the petition they brought was for a declaratory judgment. They got their answer. The answer was they have an ownership interest. They didn't get they didn't get the answer that it should be 2%, 4%, 8%, or 10%. They didn't get that
So
answer.
how is that supposed to be figured out? Or you're just supposed to all?
Well, that issue is not before the court. I mean, we've been litigating this.
Petition is?
We've been litigating this case since 2004.
I see that.
Right, and the status quo is fine. There's no reason for this court to determine what the specific interest, because they already asked for a specific interest, and they got an
didn't get it.
answer.
Not
Their answer was the ownership interest. They never appealed. The appellate division said, we're okay with the surrogate's court decision.
Appeal to whom? The Court of Appeals could not have made a factual finding like that. What are you talking about?
I said that the appellate division.
Right, so you're saying if they were unhappy with that decision, they should have appealed. The
If
appellate
they were
division-
unhappy with the surrogate's court
They
decision.
did appeal.
They did not appeal.
Who appealed for the?
I appealed.
Okay.
Right. They did not appeal. That was their remedy. Knows that. So why should they get a second bite at the apple when all the facts, the entire dispute was before the court already?
Okay, let's hear from counsel
Yes.
for the other side. You'll have a few minutes on rebuttal. Thank you very much, Mr. Fight.
Thank you, Your Honors. Jeffrey Young from Riley Safer, Holmes and Kinsella on behalf of the respondent. Let me just say the lower court did a yeoman's work going through the difficult procedure at the surrogate's court. And I think through that process discovered not only the reality, which we discovered, is the status quo is not fine. We have no rights that are enforceable in any respects. And the way the surrogate court left our client is we have an unspecified ownership interest in companies for which we have no rights to actually enforce.
Did you ask for a specific percentage interest in the surrogate's court proceeding in the second department?
In the second department, no. What we had sought after the surrogate court's March 2016 decision, which fundamentally changed how anyone understood how they could be owners in the company when the surrogate's court threw out the share certificates and looked behind what our client's ownership interests derived from actually purchasing the real estate. What we actually did is we determined and took to heart what the surrogate said, which is there aren't the necessary parties to actually make a full finding of who owns these corporations. And so in that intervening time period, we attempted to mediate unsuccessfully. And once we knew that that was a non-available option, we brought this action where we named everyone who had an express interest in the companies. And that's why we have now purely a declaratory judgment action. And as the lower court determined, through well-reasoned, thoughtful, considered all these statute of limitation arguments, which, to be frank,
Did the other parties appear in this case at any time?
they have, discovery's ongoing simultaneously.
But have they appeared, all these other parties?
They've all accepted service, and they have been in the case. And they're actually, as I understand it, engaging in discovery. And I guess just let me to also get to the point of res judicata and collateral estoppel. It should be undisputed. The surrogate's court was very clear that he was not deciding specific ownership issues, and that issue has never been resolved and still remains unresolved. And on top of that, a critical factor that's also missing is the parties aren't the same. The only two parties in the surrogate's court are not the only two parties in the presidential.
Can you go back and address what counsel said about the accrual date for the statute of limitations? I mean, why is he not right that this whole thing accrued in 2007 and you're just way past the time?
Well, number one, the appellant's theory on accrual is based on a conversion action. So a 3-year statute of limitations. That is not what we're
Yeah,
seeking here.
but now, I mean, it's 14 years after, I mean, it's a lot of years after 2007, I think, you know, like 17 years later. So how do we get that into the 6-year statute of limitations?
And I think the fundamental flaw of appellant's argument is that they just do not recognize that the surrogate's decisions in 2016 fundamentally changed who are owners in the corporation. His client is not an owner.
That gives you a new statute of limitations?
It created a new justiciable controversy for which there had never been a ripe and mature dispute about.
And that
specific
affects the
ownership.
accrual date?
It absolutely does. Prior to those decisions, everyone, because these are closely held family corporations, understood that the share certificates controlled who were owners. Once the surrogate threw those out, said they're unenforceable and invalid.
Well, they weren't signed, I thought, the share certificates.
But in the context of a closely held family-run corporation, they thought those were sufficient. They also didn't expect one of their siblings to claim complete ownership, which was what originally led us to bring the first lawsuit. It was only in 2016 that anyone understood that there was an actual question of who the owners of the companies were. And if there are no more...
So what did you think the ownership interest was at that time? The
We all-
20, 24, 4, what?
We understood the share certificates to control.
So you were relying upon the unsigned share certificates?
That's what everyone had relied upon since the day the companies were formed in the 1970s.
So there was never a question in 2007 as to ownership, right?
The only
or
question
any interest.
Yeah, the only question that arose in 2007 was after Chung Lee and his spouse had passed and deceased, and that's when Nancy, for the first time ever, claimed she owned 100% of the companies. And that, at that point, there was not a question.
Ownership was in controversy starting back in 2007.
Not ownership. What was in question was the fact that
Percentage of ownership?
Yeah, that she was taking control unnecessarily and without any support or basis.
But in 2007, essentially her claim was to 100% ownership of the company.
But her ownership claim was based on a gift from her parents who were deceased. And so that was the issue in the surrogate's court. Was there any evidence of a gift? It wasn't specific percentages of ownership. It was only, did she actually get ownership through a gift from these now deceased parents? And
To get it as a gift would mean that there was no amount left for your clients.
No, it would mean that at one point in time, our client was an owner, but it was unclear at what point he maybe did not become an owner. But that issue was resolved in the surrogate's court because there was no evidence of a gift that had occurred. And so that's why the surrogate left us with the undetermined amount of ownership, which still remains unclear, and as I think the lower court recognized, gives us no meaningful control
But
or
to
right.
be clear, your clients were aware in 2007 that Nancy and Nancy's estate essentially were claiming complete ownership of this company.
They were only aware that she thought she got a gift for the entirety of the companies from my client and his spouse. So what was undetermined was when that occurred, how it occurred, and those issues are now resolved because there was no gift. So it does leave open the question, what is the percentage ownership of my client? What's the percentage ownership of anyone, including Nancy? At present, Nancy has no ownership interest under the surrogate's court ruling. So this is not a status quo that is satisfactory to anyone, and that's why this action needs to continue.
Okay, I'm sorry. So I guess it's outside the record. Okay, thank you.
Okay, thank you.
Just a couple of points. I mean, if we look at the petition in the surrogate's court, I mean, it's crystal clear that they knew what was going on. They knew what they wanted. They knew we claimed 100%. They asked the surrogate.
Is that dating back to 2007?
That is dating back to 2007.
I'm just making sure because that was the last question that I posed
Right,
to the adversary.
because maybe they brought the proceeding in 2010 on the eve of the statute running out within 2 weeks. They brought it in June. Was the original petition. That petition got dismissed on procedural grounds, and they got another 6 months and filed a second petition in December. But what's critical is that they asked for, and their wherefore, for an inquiry be made regarding Title II and ownership of the decedent's stock
And
interest.
this is the petition in the surrogate's court?
In the surrogate's court in 2010. Now, the surrogate made a decision. They weren't happy with, they were very happy with the decision because they, for whatever reason, they didn't appeal.
So they didn't, that was the one that said, you have an interest. I don't know how much, but you have an interest.
Right.
And you can get your documents. And they never appealed from that.
They never.
You appealed because you thought you were
Because
correct.
I made a motion for summary judgment.
Because you thought your client owned 100.
Right, no, I appealed because on statute of limitations grounds, and the reason I appealed was I said that the accrual date was earlier than 2007. But the surrogate and the appellate division didn't agree with me. They said the answer that you put in was that was the date, 2007, when the world knew that you affirmatively, definitively gave specific notice to the world that you own everything. So why did they bring the petition in 2010 on the eve of the statute running out? They called it a conversion and a declaratory judgment action. I just read to you from the complaint in the current action where they admit specifically that the petition, the 2103 petition in 2010 was a hybrid. It was both a conversion petition, which is what the appellate division held, and it was a declaratory judgment action. One final point, and then I'll shut up and sit down.
Well, it looks like you'll be going on with this case for years and years and years. So, you know.
Well, if the court reverses, it's gonna end very quickly. But the other point that I want to make is that the surrogate himself, in the decision, said that the case that was litigated, actual case, was in the nature of a declaratory judgment action. What does that mean? That means that they put into issue the 20% that they claimed that they owned. And we said we owned 100%. They didn't get the decision that they wanted. They should have appealed. They didn't appeal. Thank you.
Okay, well, thank you all very much, and good luck to you guys. We will take a look at this carefully. Thank you. Okay. Now I can say, in a way I don't usually last, but definitely not least. So almost last. Okay, so we're going to start with the first 7 cases. Is that what I'm starting with? Or no.
The city is the appellant in 8 matters. The 205 is a double feature. The city's appeal, I'll argue with the other side.
What cases are you arguing right now?
So I'll argue the city's appeal on Fordham Hill through 205, and then
okay,
and then
okay, let's do one. All right, so you've got 7 minutes to talk about this. 7, I guess it's 7 appeals, right?
There's 8, yeah, including the 205.
Okay,
City's
fine.
appeal on 205.
Okay, fine.
Great. Your Honors, good afternoon, Eden Burkett. So I think that we can be relatively brief. I don't think we'll need the full 7 minutes here. The 8 appeals in which the city is the appellant are materially identical to a matter that this court decided last January, which is the matter of 3061-63 3rd Avenue. It really is identical, and we would ask that this court reverse the judges in the decisions in this matter, which are again erroneous according to the decision that this court held in January.
Okay, so few of these properties changed classification from one year to the next. What was the cause of that change? So from 2014, it went from a certain tax number to 2015, there was a change made. Was there a reassessment that was done?
I'm not sure if there's a specific case that Your Honor has in mind, but the issue before the court has to do with the purview of the clerical error rule, which is 19 RCNY Chapter 53. And what the claims that are being made that petitioner is raised through this administrative process are substantive legal disputes over the interpretation of the classification statute.
So you're saying these are not errors? These are not clerical errors?
And
or-
yeah, as this, and just to sort of, this court closely reviewed the administrative rule, and there's essentially two provisions. The rule, I should say, that the rule implements the administrative code, section 11206, and it provides authority to the Department of Finance to correct clerical errors and errors of description. So there are two terms, and then the rule further clarifies, and what this court did in the 3061 case was it looked at, well, clerical error is defined as a minor mistake or inadvertence. That's not what's being claimed here. They're claiming that the department made a legal misinterpretation, not that someone pressed the wrong button or wrote the wrong numbers.
But error of description, that you described what was physically on the property incorrectly. You called a residential building a commercial building. You said it's a vacant lot and there was a building on it.
Yeah.
Isn't that an error of description?
So an error of description, this court looked at the rules, and there was several specifically mentioned. One was whether there was an inventory error or a property misdescription. And there really is no dispute here. That's vacant land. The question is a legal dispute over the meaning of the statute.
So, no, because I think, okay, let me ask you, an Article 7 proceeding, right? That you're saying has to be brought for misdescription, or you're saying that's the one that you have to bring if there's a substantive?
Yes.
Okay. So you're saying they brought the wrong form of proceeding.
Correct. Yeah.
They could not bring an Article 78 proceeding. They had to bring an Article 7 proceeding. What's the difference in timing?
The difference between the two mechanisms.
Right. Why can't we just convert this into an Article 7 proceeding?
Okay. So there's several reasons. So Article 7 is the legislature's exclusive remedy for valuation and misclassification, and it's a yearly process. So just sort of general overview. The assessor releases the assessment every January.
Okay, let's speed forward. There's a disagreement as to whether or not your assessment is correct. Then what happens?
So so there's an administrative review, and then there's an Article 7. It's a yearly process, and there are strict deadlines. So so there's sort of two ways of looking at it. If the property owners in these matters, if they had an Article 7 that was preserved, that is their exclusive remedy. If they didn't, they waived the right.
So you're saying until next year or forever?
Well, no, it's a yearly process. So
okay. So you're saying by mischaracterizing this, and there's no right under Article 7 to come into court?
If they had an Article 7 challenge saying that the properties were misclassified, that is their exclusive remedy. What they're trying to...
When you say that, what does that mean? To go where? To do an administrative process?
Well, the Article 7, it starts as an administrative
And then where
challenge.
does it go if you don't resolve it there?
So there's an administrative challenge before the Tax Commission, and then the Article 7 has to be commenced in New York Supreme Court prior to October 25th.
Is it like a tax
Those are tax certiorari cases?
It's a tax certiorari part. There's there's 4 specific parts in New York City. There's a special tax certiorari part, and they hear these matters, and it preserves the consistency.
Some of the petitioners have filed Article 7.
There are, yeah. So some of them have Article 7s, in which case that is their exclusive remedy. If they haven't, they've waived the right. And
what do you say about, there was a decision, I understand it's from the Second Department about 10 years ago, that went through a long discussion and found that Article 7 was not the exclusive remedy. Rather, other than saying, I don't agree, how do we distinguish that? Why should we not look towards possibly following that?
Well, this court has cited that case, and
Yes.
this clerical error provision has spurred several cases that we cited in the brief. And the way that I would think about, the way that I would say is that this court has cited Better World, for different propositions, you know, and I think that there are parts of the decision that are correct and there are parts that are not correct. However, you know, I think that all said
What
and
part of Better World is correct?
well, the court said that it is the administrative review process under this clerical error provision is discretionary in nature, and I think that our adversary is arguing the opposite, that there's no discretion. So again, like what is a clerical error or an error of description is essentially it is a matter of like does it fit the purview of the statute 11206, which has a you know an interesting, I think, legislative history that's described in the brief. It's a narrow, very narrow exception to the Article 7.
Can you just for 1 minute, you said, well, if it's a vacant land, so tell us if it's a vacant lot, where that would fall, that it would not be a description, an error in description if it's a vacant lot?
Well, I don't know if I could give you a sort of a definitive answer because again, it is a sort of a discretionary. There are probably various ways in which there could be a clerical error, for example, or there could be an error of description, depending on every case is unique. However, in general, what I would say is that the question of there are under RPTL 1802, there is a very complicated scheme about some of the vacant land is in Class 1, some of it is in Class 4, and the issue that's presented in these cases, as well as dozens and dozens more that have been filed, is really a question over a key phrase, which is not zoned residential.
Right.
So it really is, and that itself has its own complicated analysis, but really ultimately that is a fundamentally a legal question that is not appropriate for a very limited clerical error review.
So I have two other questions. One, yes, relating to that, there's one of the Second Department cases said that we should read it broadly, and so not zone residential should mean, is that what not? So that even if it's partial, an overlay with commercial doesn't take it out of being zoned residential. Isn't that what it?
Yeah, there is a case, short development. It was interpreting Nassau County zoning, which is different than New York City zoning. Again, like these are complicated questions that involve facts and law, and are really sort of not they're not encompassed by. They were never anticipated when the legislature created the 11206 review mechanism, and it was not anticipated, nor is it anywhere in the rule. And this court looked at the rule carefully and found that legal claims such as the exact, I mean, really, this court decided this exact issue already, and found that these are legal claims and they're not cognizable in the rule.
So my last question for now is. When these proceedings, before they became court proceedings, were in the Department of Finance, and they made their applications, and it came back with one sentence with no explanation. I mean, what are people supposed to go on? Is that appropriate?
Yes, Your Honor, because it is a very narrow question. The only question poses, we think that there was a clerical error or an error of description. The answer is
and you just say no, and you
there
don't
wasn't.
give them any answer. Why? No discussion, nothing. That's it. I mean, that's good, I guess, if you can get away with
well,
that.
that's what my adversary is arguing. However, the case law is clear that assessments are entitled to a presumption of validity and correctness until they are rebutted within an Article 7 proceeding with substantial evidence. So the case law is clear that they're trying to shift the burden to the assessor in a limited purview.
So basically you're saying they could have challenged in an Article 7 proceeding our determination that this was a 4 instead of a 1, but they didn't do that. What they did was said this was a misdescription, and that's an easy thing. Either it is or it isn't.
Yes, it's a simple question, and it really, like, what they're trying to do is they're saying, oh, this was a clerical error or an error of description, and then the assessor is, no, sir, you're mistaken, and they're saying, oh, well, you're wrong on the law. Well,
let me ask you, both those determinations you're saying have to go through an Article 7 proceeding.
I'm sorry?
Both those objections, you're saying,
Yeah, well, so
have to go through Article 7.
The exclusive remedy is Article 7. I think that the clerical error review provision under 11206 was really giving the department discretion to fix what are really manifest errors, like on the face of,
I gave you 10 more yards than you're entitled to.
it was a it was a $1 million square foot instead of 10 square foot, but really the question is that the property owner is apprised of the assessment and the classification, and they're given an opportunity to challenge. If they sit back and say, no worries, and then years later they say, hey, wait a minute, I think I might have a claim, that is inconsistent with the structure of how the legislature intended, because it's meant to be a very strict set of deadlines. It's meant to be a narrow time frame in which property owners must exercise their rights, or and this is really a sort of a very narrow exception and is not appropriate for the claims that are being raised.
Okay, let me ask you, if I may. 5302 basically defines what would be a clerical error or an error in description. And you have 530210 that refers to inaccurate building class that affects assess value. So if they claim that you gave it the wrong building class and that this affected the assess value of the property, wouldn't that be considered a clerical error?
I mean, I think that it would depend on the circumstances, but not in the way that it's phrased here. The way that it's phrased here is essentially it's opportunistic to call it a building class dispute when really it's a legal.
Why? Why is that opportunistic to call it a building class dispute when they're arguing, and that's what your description says, a particular class, which brings it into a particular tax class, and they say you gave it the wrong class. Instead of V0, you gave it V1 or V4.
The building class doesn't determine the assessment. It really is a sort of it's simply a label that the assessor ascribes. Really, like the operative dispute is a substantive dispute over whether or not a residential property or vacant land that has a residential zoning, but with a commercial overlay, which the Department of City Planning has held that is a commercial zoning, whether that means not zoned residential. That's really the core dispute, not about whether or not because ultimately the question about the building class leads back to the legal dispute. Over what does the statute mean, and it's simply not. It would essentially be it's an end run around the Article 7 process.
Okay, let's hear from the other side. Okay, I gave you a lot of time. Good afternoon.
Good afternoon. A little shorter. My name is Todd Kammerman. I'm here on behalf of the respondents. Petitioner respondents in these 8 cases. May it please the court. Justice Mendez, I think before you asked your question, I was going to start in the same place, because if you notice, my colleague does not want to talk about the clerical error rule and that description of that specific clerical error that says, in plain English, erroneous business class. And I understand that my colleague tried to minimize what a building class is, and it's not important, but that of course raises the question then why they put it in the clerical error rule to begin with.
Is there a building on your property?
It's a vacant land.
So there's no building. So why would building class matter?
Because building class...
Isn't it talking about a building on the property, whether...
No. It's building class V1. That's what they classified it. Building class V1 is vacant commercial.
So
they assigned it an erroneous building class. It should have been building class V0, which is a residential vacant land.
There's a vacant land can be residential or commercial?
Yeah, well, it has residential zoning.
Because of the zoning.
Because of the zoning. It has residential zoning and it has a commercial overlay. So we do not concede that you cannot that the clerical error rule does not allow you to address a clerical error or an error description that arises from a legal error. There's no state of mind discussion in the clerical error rule about why you assigned it an erroneous business class. It just says if there's an erroneous business class, and that's what's here. However, there is no legal dispute here. There's a manufactured legal dispute. If you look at the city's papers, there is not one cite to any legal authority that says that a vacant land with mixed zoning or residential zoning and a commercial overlay is zoned commercial, should be building class V1.
No, that's their arguments that you brought the wrong proceeding, that you should have brought in Article 7 proceeding, not in Article 78. And we literally have just held that.
Well, I respectfully, I disagree. And first of all, we have to get off of this Article 7 versus Article 78.
Well, I mean, you might, but we want to talk about it.
No, I will talk about it, but...
So let's talk about it.
Right. This is not Article 7 versus Article 78. This is Article 7 versus 11206 clerical error rule, that procedure. There are two procedures here, Article 7 and 11206, and the Department of Finance under 11206 codified a procedure under the clerical error rule.
Let me ask you this, before you go into that, into your argument. Does an assessor need to make a judgment call to classify a property either commercial or residential?
Does he need to make a judgment call? No, because it's clear. The law is clear.
It's in a record, someplace you can push a button and it'll say, this lot is zoned commercial, this lot is zoned. You don't know that.
Respectfully, I do not know how things work in the Department of Finance's office or the Department of Buildings.
At one point, the lots were zoned as vacant resident, Class VO, and then it changed. How did that change occur?
Well, it's an interesting question. And in the Fordham Hill matter, which is the first one on this list, which is 2023-04965, the judge held an the lower court held an oral argument, and the judge asked the city that very question. And if I can find it, the judge asked that question and said, couldn't this be just because it was a mistake? Someone, 1 year it was right, and then 1 year someone just clicked the wrong button or checked the wrong thing. And the city couldn't, and it's in our briefing for Fordham Hill, the city could not answer that question. They said they did not know why it happened.
All right, and
so the clerical error rule, I think maybe we should start with Better World, because Better World is how the clerical error rule started. In 2014, there was a case in the Second Department called Better World. And
why would we start in Second Department? Why won't we start with the case that we just decided recently that the facts are very similar?
Well, because the clerical error rule was enacted in the wake of Better World, and it codified Better World's holdings. So I understand that obviously this court is not bound by what the Second Department says, but that case has unique significance here because, and I'll explain how.
But I guess what I would like for you to explain first is how do we, are you asking us to reverse our own decision that we just?
Absolutely.
Okay.
And I'll tell you why. There are a number of reasons that 3061-63 is wrongly decided. In that case, the court seemingly accepted the city's representation to the court that it had no authority to make this correction. They say that outright. However, the record is full of numerous examples of them making this exact correction under the clerical error rule, under this procedure. So when they say it can't be done except for under Article 7, I hate to say it, objectively that's not true, and the city is not telling you the truth. It's objectively false. There is example after example after example in the record of them doing the exact thing that we were asking here.
And is it similarly situated properties?
It's vacant land that was zone V1, that tax class 4, and they corrected it through the clerical error rule.
All in the Bronx?
A lot in the Bronx. I mean a lot in this. I have one in Queens.
And it's a part of your record that you submitted?
It's part of the record. In Fordham Hill, it's R309, 96th Street, Queens. The property is a vacant land outside Manhattan, residentially zoned. 4A, a commercial overlay, 1-3, 55%. It was taxed class B. It was building class V1 TC4 through 2021. And in September 2020, DOF corrected it through the clerical error rule to V0 TC1. And in fact, we mentioned this in our brief, after 3061-63 came down, the city again made this correction that we're asking.
And these were all settlement agreements that they made, or these
No,
were all
I
administrative
don't.
decisions?
Some of them are settlement agreements that are in the record, and some of them are just properties that we've found through public records on the city's databases, and they've never, ever said that there's any difference.
Did they ever start out as an Article 10 proceeding?
What?
Did it ever start out as an Article 7 proceeding?
Those were not Article 7s. Those were clerical. You could see it says in the property records clerical error correction. I can continue about 3061 in your question about.
Yeah, go ahead. I'll give you an extra few minutes.
So in Better World, the court rejected 3 arguments that the Department of Finance made. They rejected the argument that, they rejected the argument that clerical error review is limited to errors of mere form. The DOF made that argument in the second department in Better World. They rejected that. The DOF also made the argument about the legislative history of 11206 and that it should be narrowly construed, citing all these cases going back to the aftermath of the Civil War. The second department rejected that argument, and they said it should not be narrowly construed. And then what the second department also, the city argued that RPTL Article 7 is the exclusive method to challenge misclassifications, like we have here, and the second department rejected that. So what happens 2 years later? 2 years later, the Department of Finance enacts the clerical error rule under 11206. And this is all in the record, but what does it do? It says in the preamble that the definition of clerical errors and errors in description should not be narrowly construed and are going to be interpreted much more broadly or corrected much more broadly than they were in the past. It also, as you can see in the clerical error rule, has a long list of errors that can be corrected, including misclassifications. And again, they argue that Article 7 is exclusive for misclassifications. It's not. It's in the clerical error rule. And like I said, they correct this exact misclassification all the time.
That doesn't affect whether or not you have to bring an Article 7 proceeding or an Article 78 proceeding.
Absolutely it does.
Why?
Because you bring, through the clerical error rule, you request administrative review with the Department of Finance through a clerical error request. And in fact, the Department of Finance has this big website. If you have a problem with your property, it has the whole list of all the errors and says, this is the way you can do it. You could go Article 7 or you could go this. And the clerical error rule has a 6-year look back, unlike Article 7. So it gives you a much longer time.
The clerical error rule, what are you referring to? Is there
19 RCNY 53.
Okay.
It's in the record.
Okay, yes, I have it.
So once the Department of Finance issues its decision, its administrative decision, like you were talking about the one-liner that tells you almost nothing.
Right.
That if we deem that, if we believe that decision was arbitrary and capricious, that administrative decision, there is only one procedure to use to challenge that, to ask for judicial review, and that's Article 78 of the
You're saying
CPLR.
you couldn't bring a tax certiorari?
No, you can't. This has a 6-year look back. Tax certiorari, if, let's say you want to review fiscal year 2025, 24-25. You have to bring that tax certiorari by March 1st or March 15th of 2024.
And
Well,
there's no look back. I mean,
There's
it's
no
just
look
a
back.
one-year thing.
That's right. While the Department of Finance itself, in the clerical error rule, says you have 6 years to do this, and now you come and you do it 4, 5, 6 years later, and sometimes they say, sorry, no, and then when you challenge them, they say, you can't do it this way, even though they've done it scores of other times, the exact thing.
With other litigants.
What?
With other litigants?
Yeah.
With whether it's through litigation or whether someone just filed an administrative clerical error rule and they never denied it in the first place. They granted it.
Just tell me where in the record that you have evidence that the city has changed from 1 to 4 through the clerical error rule.
Sure. Let me pull out the records. In the Fordham Hill record, which again is 2023.
We have it.
You said record 309?
What?
Did you say record 309?
He didn't say it.
Oh.
No, the record on appeal in Fordham Hill, which is case number 20.
Yeah, we know which case it is.
Okay, sorry. If you look, in the pages 406 through 433 are 5 stipulations of settlement where they corrected this error.
Oh, that's a different thing. In a stipulation of settlement, you can do crazy. Whatever. If everybody agrees on it in a stipulation of settlement, I can say whatever I want applies. I'm asking you whether the city has ever done this review under that rule and changed it without a settlement.
Well, okay. So, yes, if you look at example A, exhibit A starting on page 307 to 397. And I just want to say the stipulation of settlements, it was a case like, a matter like this, where they agreed to exercise their authority to make this very change.
Under the clerical error rule?
Article 78, in the context of an Article 78.
In the context of an Article 78.
So that case started as an Article 78, and they stipulated to settle utilizing the clerical error
That's
rule.
correct. And we all know that if you don't have authority to do something, you can't gain that authority by agreeing to do it in a settlement agreement.
I have a quick question for you regarding 1953.
Sure.
Under the definition of errors in description, where examples are given, it says incorrect tax classification on the assessment roll due to an inventory error concerning the records maintained by the department or the physical characteristics of the property. Is that where you're resting your argument that this is an error in description that the Department of Finance is empowered to correct?
No, that is B1. I am doing it under B10.
B10, okay.
Inaccurate building class that affected assessed value. And that is spelled out in our papers, and it's spelled out in the Article 78 petition. And that's the error in description we're alleging.
Okay, thank you. Let me hear briefly from you.
I'm sorry.
Any rebuttal? Yeah.
Counsel, just so we're clear, why doesn't this fall under the definition of an error in description under B10?
Because it is not the purpose behind that. And again, the Department of Finance created this rule, and they did not intend to permit the substantive challenges to the misclassification.
Well, I must say, rules and statutes sometimes do have unintended consequences. That's not.
But the department doesn't have the legislative history has demonstrated, and the case law has demonstrated that clerical errors and errors of description are narrow ministerial errors.
Yeah, but it says, but this starts out with saying the Commissioner of Finance may correct any assessment or tax that is erroneous due to clerical error as defined in what we're reading. And if the allegation is that it is defined as an error in description under B10, why isn't it that the court can say the Department of Finance, this is considered a clerical error or error by description based on your own definition?
Because it's not consistent with the meaning of 11206 or it's not consistent with the enabling
It
statute.
seems that what you're doing is not consistent. That's what I'm.
Well, no, respectfully, the city, vehemently disagrees with petitioner's characterization that it is running roughshod and granting this, the exact same error to other properties. Each property is evaluated on its own circumstances, and
But even if each property is evaluated on its own circumstance, then it still wouldn't be under the umbrella of clerical error or error in description. It would still be under, if it's the same thing, right? If it's the same argument.
But it isn't the same thing.
It's about whether, in fact, the tax class is V1 or V4.
No, it isn't about it. Again, the entire purpose of the 11206 and the rule is to permit the assessor to correct what in the assessor's judgment were either minor mistakes or inadvertence, or an erroneous description, but not to correct substantive errors. And I just want to sort of like to emphasize that petitioner's self-serving statements that the department is granting these substantive errors.
Oh, it's based on some stuff in the record, right?
Well, these were all raised for the first time on reply, which again,
They weren't, I'm sorry, weren't they addressed at the trial court as well? It came up in oral arguments.
Well, but this is, and this.
So it's not a surprise, right? Because you
Well,
heard about it at the trial court in oral arguments.
In some ways, these are raised for the first time on reply, and to say, well, here's a whole we dug up all of these examples. Spend all of your time sort of not that one, not this one. It would require a mini trial for each of the examples when really all they are the their self-serving statements by petitioner's counsel trying to create a collateral issue, collateral trials. What about this property? What about that property? But what about the property in front of the court? And the problem is that the allegations are substantive legal claims. They're not clerical.
How was the building class designated in this case?
Well, in all of these cases, it flows. Look, I'm not the assessor, and that's not in the record. All of the process, but ultimately, what this court already looked at that exact provision and found that it did not apply to the claims. In fact, this court made a distinction, a compare and contrast between the facts of Better World, which was an inventory error. An actual physical misdescription, right? A property that was a two-family that with a garage that was described as a three-family with a store, a totally different class, and compared it with the shore development case, which was a claim about the interpretation of the classification statute.
Keeping it here, this particular property had a particular building class 1 year, and then the next year it had a different building class.
Well,
how did that happen?
Well, there obviously we have many cases, and the facts.
Isn't that a clerical error? I mean, sounds like a clerical error to me.
I mean, I think that in the abstract, again, the principle is that even the court in Better World found, and the statute itself, 11206, says that it is a discretionary power. And it is really within the purview of the Department of Finance.
But it shouldn't be arbitrary, right? So there should be some rhyme or reason to it. It shouldn't just be, well, in certain cases it changed or we don't know why it changed. There has to be a reason for it.
Every case is unique. The assessment process happens every year.
But you haven't told us what's unique here, right? This is the case that you came in to argue about. If 1 year it was classified as a V1 or a V0, and then another year it went to a V4, there has to be a reason for how that change came about.
Yeah, especially when it affected the assessed value of the property.
Respectfully, the building class is simply a label that the assessor affixes after they determine based on the zoning of the vacant, number one, is it vacant?
So if this was a V0 or VO residential, then the tax class wouldn't matter. It could be class 4.
What I'm trying to say is that the determination is based on, a whole, the assessment process is extremely complicated. And so, but to simplify it, it's like, is this property vacant land, number one, and what is the zoning designation? And what we've sort of stated, the policy is that commercial zoning, which is the commercial overlay, tips it into the class 4. Now, when it tips into the class 4, they call it a V1. If they look at it and say, this is pure residential zoning, they say V0.
One year, somebody could say, oh, it tips this way, and another year, they could say it tips that way. Okay, you know what, we have to, stop. Who's next, and we're not giving you this much time. You're next? You're next for the cross appellate in 205, but a different person is going to be the petitioner. Oh, now you have to switch to that side. Oh, okay. All right, so this is just
Just the cross appeal on 205 West.
All right, well, we're not going to take quite as long on that, please. Okay. Yes, good
May it please the
afternoon.
court. So what the issue in 205 was the
Stipulations of settlement.
Stipulations of settlement. And so we all understand that settlement releases are generally enforced. That's not a proposition that we argue with. But there are two reasons here that those tax settlement releases cannot be enforced. One is they waived it. As a number of you mentioned in the last argument, the administrative denials only had one sentence with not a lot of description. The Court of Appeals has been crystal clear that in an Article 78 proceeding, and I could read from the Trump equitable case, fundamental principle of administrative law long accepted by this court, meaning the Court of Appeals, limits judicial review of an administrative determination, which is what we have here, solely to the grounds invoked by the agency, which would be in that one line that you all are looking at. And if those grounds are insufficient or improper, the court is powerless to sanction the determination by substituting what it deems a more appropriate or proper basis.
So are we, do we have the authority to send it back for a more extensive evaluation? Or?
Well, I think the purpose of an Article 78 is to judge the administrative determination that was made.
Right.
So I don't believe that, I don't believe.
When did you settle? After the administrative determination?
No. There was a tax certiorari settlement years ago.
Right.
This clerical error request requested that other parts of that assessment from the same year, that there were errors, be corrected. And what they're arguing is that there is a release in the tax settlement.
Is there a release?
There is absolutely a release.
So how could you possibly get away from that?
Well, there are two ways. One is they waived it. They waived it because they didn't invoke it in their administrative
Did they raise it in the Article 78 proceeding?
No. No, they didn't raise. What the Court of Appeals says.
I'm asking you whether they raised it.
Yes, they did.
Okay.
They did.
I'm satisfied. Then
Right.
what? And then
They
what?
did.
What's your other ground?
What?
What's your other ground, counsel?
Okay, I would like to
You
finish.
said you had two grounds.
Yeah, but I would like to finish on the first.
Okay, but
The Court of Appeals had said in an Article 78 proceeding, you cannot sustain an administrative denial on grounds that were not invoked in that denial. That's what the Court of Appeals has said in Trump Equitable and in numerous cases. In fact, and the First Department has repeated that principle over and over again. And in fact, the Second Department had says, even if there's a raised judicata defense, even if this exact issue has been litigated before, if the administrative agency does not raise that in its denial, the defense of res judicata is waived, which is remarkable, but that's the law. That's the law. And res judicata is even stronger than a release. Like, you know, you learn about res judicata your first day of law school, you can't litigate the same case twice. The second reason, and even if it's not waived, and it's going back to things from our first argument, is that disparate treatment is unlawful. And we have in the record in 205 West 62nd Street, numerous other properties where a clerical error correction has been made after a tax commission settlement for the same years. So, and what the Court of Appeals says in the Charles A. Field case is in a decision by an administrative agency which neither adheres to its prior precedent nor indicates its reason for reaching a different result on essentially the same facts is arbitrary and capricious. And the Court of Appeals has also said in the same case, the reason for this is the importance of requiring consistent results, provide guidance, deal impartially with litigants, promote stability in the law, allow for efficient use of the adjudicatory process, and maintain the appearance of justice. And what we have to remember here is this is not a settlement between two private parties. If you have a private party who enters a settlement, the same settlement agreement with 5 parties, and then they all litigate against them again, that the private party could say, well, I'll waive the settlement release against these 2 and not against the other 3. They can do that, but the government can't. The government has to do it in a uniform basis. These releases either apply to a clerical error request or they don't. And you can't do it one for one and different for another. The government cannot act like that. And that's exactly, it's in the record, and they don't dispute. They never talk about those releases that are in the record. They can't talk about it because once they talk about it, they have to admit that there's disparate treatment. And disparate treatment is plainly unlawful. It is one of the worst things that the government can do, is to treat similarly situated individuals differently for no reason.
Thank you.
May it please the court, my name is Yair S. Goldstein for respondents. This court should deny the appeal of the denial of the Article 78 proceeding with respect to tax years 2017, 2018, 2019, and 2020. The issue of settlements with tax commission settlements foreclosing this type of litigation has been decided by this court in 2 recent decisions. One being matter of oversight management services versus Solomon, and the other one being 174th TIC owner LLC, which was decided shortly after respondents submitted their reply papers. I have therefore put through the court's electronic filing system as document number 24, a copy of that opinion. Petitioner's counsel has made the exact same arguments that he's making here today in the matter of oversight management services case. The first department considered those arguments and rejected those arguments. And counsel proceeded to move for leave to the Court of Appeals and made once again those arguments. And leave was not granted. In the recent, and we're talking October 1st, 2024 decision, 174 TIC owner LLC case, this court wrote, quote, petitioners entered into a settlement agreement with the New York City Tax Commission in the 2019-2020 tax year, in which they agreed to waive their rights to further review of the current and prior assessments. This agreement forecloses judicial review of the 2019, 2020, and prior year tax year assessments, citing, end quote, citing the oversight decision. In this case, the terms of the settlement agreements are in the records on pages 416 through 419, sorry about that. And the arguments have been made. They got the benefit of their settlements. That is what they received. They got the benefits of their settlements, and ultimately, now they want to come back. And they were, incidentally, they voluntarily entered into these settlements represented by counsel. Not this counsel here, but tax certiorari counsel represented them, and they chose to enter into these settlements.
What about counsel's argument that the city is treating people differently who are similarly situated? They're giving this opportunity
This
to
argument
others.
was raised in the reply papers in the court, and where, again, we do not get a cert reply. And each one of these cases involves different sets of circumstances and so forth, including the possibility that perhaps the person who made that decision, it wasn't a decision, didn't realize that it was a tax commission settlement. In other words, in their petition, or in their petition to this court in this Article 78, they didn't say, oh, by the way, we settled with the tax commission as of these following years. They didn't put that into their papers. It's something that, personally, I dug up without giving myself too much credit. But the point is, the fact that you can say that, hey, and I don't know how many cases come up, that, whoops, you missed a few. That's not a policy decision of the city that we're going to treat certain petitioners one way and others another way. As far as the argument about the administrative record, the breach in the terms of the agreement here is that they cannot bring an administrative proceeding and they cannot bring a judicial proceeding. They have breached the settlement agreements both ways. So here, in bringing this action, they're in breach of that agreement. So there's no way, we have never waived that.
Any further questions? Okay, thank you
very much.
Thank you very much. Counsel,
Thank you. I'd like to first address the oversight decision. If you read the oversight decision, it doesn't say anything about failure to invoke, and it doesn't say anything about disparate treatment. Respectfully, the court ignored those arguments, and obviously we try to go up to the Court of Appeals, and the Court of Appeals saw a decision that just stood for the general principle that settlement releases are generally enforced. So that doesn't sound so interesting I mean, obviously we don't know why the Court of Appeals decided not to take the case. But the fact of the matter is, the release says we cannot seek review, okay? We sought review. That goes to the whole disparate treatment, that it shouldn't be enforced. But even if the disparate treatment argument didn't work, you can't apply the release twice. It says you can't seek review. We sought review, and they didn't follow the law, right? If you have a statute of limitations argument, statute of limitations is a pretty strong defense. But if you don't raise it at the right time, it's waived. If you don't raise the release, and the Court of Appeals is clear what you can, this is not a proceeding against the original assessment. This is a proceeding seeking judicial review of an administrative decision. And the Court of Appeals is clear what you can and cannot consider in such a proceeding. And it says that the court is powerless to sustain that decision on grounds not raised. That is strong language. When the Court of Appeals says the court is powerless to do something, you can't ignore that. And if this, and I will say, if the court wants to create a new exception, then at least put it in the record so like we could go to the Court of Appeals with it. I mean, what oversight did basically mimic, they ignore that argument. They ignore both arguments in their papers. They ignore the disparate treatment. They ignore the failure the failure to invoke because they're strong arguments, and they ignore it. And unfortunately, in oversight, they did the decision just ignored what they ignored, and we submit that respectfully that's not right. And one thing about the TIC the other case, disparate treatment was never raised in that, as far as I can tell. I watched the argument, I looked at the papers, and the failure to invoke was let's say, not put forth as their primary argument or very strong. But the Court of Appeals says that a court in New York State in an Article 78 proceeding is powerless to sustain an administrative decision on grounds not raised in the denial.
Thank you. Thank you both. And now we have that last case, 243 East 32nd.
Good evening. No, good afternoon.
Getting there.
Good afternoon, Your Honors. Scott Goldberg, may it please the court. I am going to be brief. I know it's the end of the day. It's just very interesting. This too involves a clerical error rule, and in this case, the Department of Finance corrected a misclassification, which they tell you they couldn't correct in the other cases, but when they corrected it, they violated the clerical error rule, and they violated my client's due process rights. The clerical error rule allows my client's property had 2 units. They were being assessed as 4 units. 2 units is tax class 1, 4 units is tax class 2. A request
That
was...
seems like a real clear misdescription.
It is.
That's not a vacant lot being 1 or 4.
But-
That's a building either, you can look at the building and see whether it has 4 or 2, right?
Right, but with the vacant lot of V0, for instance, it's zoned
Well,
R9.
I'm talking about
Right.
in your case,
yes, in
that's
my-
a misdescription.
Yes, it's a
And
building.
then what happens? So you go and say it's a
They corrected it. They did a great job. They went back. This was request in 2021. They corrected it. They corrected 15, 16. Wonderful. But what they did was the clerical error rule. Of course, Article 7 is very relevant for evaluation. If you feel that the wrong cap rate was used, wrong comps, that you have to bring an Article 7 proceeding on. And the clerical error rule says under 53-02C, errors not subject to administrative correction. And what do they list under C2? Excludes from administrative correction, incorrect valuation model utilized. So when the Department of Finance in 2021 corrected the misclassification from tax class 2 to tax class 1, they also increased my client's market value from about 1.4 million to 5.9 million. And then they said, well, we're only going to apply an effective market value of $3,321,950. Why? So it served to zero out to the penny any benefit my client would receive. So if we came to the Department of Finance and said, you used the wrong methodology here, they used an income approach as opposed to a comp approach, they would say, go bring an Article 7 proceeding. But that's exactly what they did. So they violated the law. They violated their rule. That's not the worst of it. The worst of it is our client, Department of Finance argues that my client should have commenced an Article 7 proceeding. He should have filed a claim with the Tax Commission by March 1st, 2015, that the $5.9 million market value was excessive, which obviously is impossible because it didn't happen until 5 years later. What was the value at the time? In January of 2015, the city issues a notice of property value, and they said the property was valued at $1,452,000.
How did they get to that value?
The $5,900,000? I don't know. They changed the methodology, which is not allowed, and they said based upon comparable sales, that's the valuation that
Isn't
it should
that
be.
one of the methods that they can use to?
Under the clerical error rule, it's not allowed. It says specifically errors not subject to, and it says administrative correction. Administratively, they increased the market value. And what's so terrible is there's no way we can contest this because on January 15th, 2015, my client received a notice of property value. It said $1,400,000. He would have had to file by March 1st, 2015 with the Tax Commission, and he would have had to commence an actual Article 7 petition by before October 25th, 2015. You can't charge us with being clairvoyant. And that's what's done here. And they point 2 of the brief says, this is the respondent's brief, I'm quoting, due process is not violated, they're saying, because petitioner elected to forego a challenge of its real property valuations via commencing Article 7 proceeding. Of course we didn't commence an Article 7 proceeding. $1,400,000 was fine. 5.9 is not so fine, but it came after the fact. So I ask counsel, that's my argument. Thank you very much.
Thank you. You'll have 2 minutes on rebuttal. Thank you. Counsel?
Good afternoon, may it please the court. Filaretta Islami for respondents. Your Honors, the issue that's presented in front of you today has already been decided by this court in the matter of Liberty View condominium.
And
With
what?
this matter of Liberty View condominium, where this court in 2022 held that when the Department of Finance addresses a clerical error correction, they can also use their discretion in revaluing the property. And that's exactly what happened here. Petitioner filed a clerical error application stating that the property was misdescribed. The property was being taxed under tax class 2 because Department of Finance was inadvertently had the description wrong as a 4-family home. However, this property was converted to a 2-family home, and that would have landed it in tax class 1. So the Department of Finance granted the application and issued a revised notice of property value. However, again, pursuant to Liberty View, the Department of Finance used its discretion in revaluing the property. And the reason the Department of Finance decided to revalue is because properties in tax class 2 are valued using a different methodology than those in tax class 1.
But counsel said, but then he lost his ability to challenge the new valuation. What do you say to that?
Well, they didn't, because again, the notice of property value is sent out every single year to every property owner. In this case, it is page 86 of the record where they attach a notice of property value, and in that.
Yeah, but what happened was then he went through this whole procedure with the clerical error, and they changed the amount 5 years later. He was supposed to know that 5 years before? I mean, I'm sorry, he's smart, but he, can't do that.
But they were informed that it was misdescribed by the
But how
Department
could
of
they?
Finance.
Yes, but how could they bring a proceeding just to? Well, we know it's wrong, but we don't know how much it's going to be wrong. I mean, you can't bring a proceeding like that. He lost his right to bring the proceeding for that year because he didn't get the valuation until 5 years later.
Well, respectfully, Your Honor, it's because they decided to not challenge it in a Article 7 proceeding. Again,
Why would they? Because the value that you were giving them at that point was a great value. Why would anyone challenge that?
And why would they have to if it was a clerical error, just a basic misclassification?
both of these could have been addressed in an Article 7 because they could have addressed it. They were informed that the notice of property value notified them that they were taxing it as a tax class 2A as a 4 to 6 family home, which clearly it wasn't. Had they filed an Article 7, they would have been able to challenge the classification with the error of description, and also then argued with regard to the fact that, they're arguing that valuation error.
How can they argue it until you give them a number? They're going to argue that no matter what you do at some point in the future is bad for us?
Well, I would also like to address your Honor.
I want you to address that. How do you do that? How can you do it?
Well, the assessed value was decreased. So page 84 of the record, the revised notice of property value, it all went down. So about $100,000 the first year to $123,000, I believe, the third tax year under review. So he really, there is no claim here because they don't, the assessed value was decreased. It wasn't increased. And since they decided to not challenge that initially in an Article 7, the Department of Finance should be able, pursuant to Liberty View, use their discretion in revaluing the property, again, because if you're changing the tax class, now you're using a different methodology.
I'm just trying to figure out why you think it would be okay if you're saying the number went down and that they should have challenged it. If I get a refund, I'm not challenging that. Why would they challenge that?
I'm sorry, can you just read, what do you mean?
I thought you were saying that the 3 years, they got, the property value was assessed for less, right?
It was initially assessed for more. When they revalued the property upon reclassification, it was assessed for less. So if they didn't decide to challenge it when they assessed valuation was higher, now they're claiming that they cannot.
I misunderstood you. Okay.
My apologies if I confused the court. Okay. And again, I refer the court to page 84 of the record. The revised notice of property value has this charted out on a table in a clear way to see.
Okay, thank you.
Thank you.
Just a quick couple of comments.
Sure.
tax class 1 is assessed at 6% of market value. The property was $1,450,000. The tax should have been, the assessed value should have been $87,000. So what they did was, and the tax rate for tax class 1 is about 20%. So the tax would have been about $17,000. So what they did was, Department of Finance, and tax class 2 is assessed at 45% of market value. So if you have a property that's $1 million, that would be $450,000 if tax class 2, or $60,000 for tax class 1. So what they did was they needed to increase the market value, so they applied the 6% assessment ratio, and then the roughly 20% tax rate to zero out the tax. So even though it went down at the 20% tax rate, we were grossly overcharged. Point here is the clerical error rule specifically carves out under 53-02C, things that cannot be corrected administratively. And that's the methodology of assessment, whether it's income, comps, things like that. And that's exactly what they did. And they did this to deprive my client of being properly billed. His property taxes are grossly over what they should be for comparable properties who are 2 units because of this error. And it's not even an error. And there is no possibility of coming in here and contesting this. The due process violation is so clear. January 15th, 2015's notice of property value listed $1,400,000. And now that number jumped to $5,900,000. And if you leave this to stand, they did reduce the effective market value, not the cause and imposition. What if they didn't do that and they left it at $5,900,000 and they now told my client he owes $100,000? We'd be in the same position, except my client would owe $100,000 that he couldn't contest. That's why this can't stand. It's a very slippery slope. Thank you very much.
Thank you all very much.